I did, actually. I shouldn't say we. I didn't have my kids till yesterday morning, so. But I did. I went to a wedding. Did a wedding. It was outside. It was hot. They wanted me to wear this hat. And so literally, as soon as it was over, like I was walking up the stairs, and I'm like, oh, and I had to have it all twisted up. So it went well. That was really fun. All of it was good. So,
All right.
ladies and gentlemen, you may be seated. Good morning, everyone. We are back in the jury in progress, the State of Ohio versus Raymond Tenzing, case number B1503961. We are going to begin this morning with closing arguments of counsel. We'll begin with the state, so whenever you're ready, you have the floor. I think, Mr. Graffenreid, are you closing?
First half, yes, Your Honor.
Okay.
Good morning. How is everyone this morning? We started this case what seems like a really long time ago. We're finally at the end of this. We're finally at closing argument. I always like to think of every case as a puzzle. So I always start with my puzzle here on the board. I like to think of it as a puzzle. Some cases are a puzzle where you're trying to figure out who did it, who is it. As Mr. Teeger told you in Bordar, you don't know. Well, that isn't this case. This is more of a puzzle, just like any other puzzle you do at home. You have the puzzle, you have the box, you might know what the picture looks like, some people might put it away. I'm going to walk you through what I believe the evidence has shown you. And at the end, the state believes that you will find the defendant, Raymond Tenzing, guilty of murder. This was a long case. There are more than 20 witnesses, including defense witnesses. Sorry, this is we had over 100 pieces of evidence introduced. Now let's review this evidence together. We had, the state called 16 witnesses. If you remember, we started way back with Lieutenant Barge and ended with Dr. Lohman, including the several witnesses that the defense called. That's over 20 witnesses to help us piece together what happened on July 19, 2015. This is an overview of some of the exhibits that have been introduced and some of the evidence. It's all here in these boxes, and you'll have a chance at your leisure to go through, look through everything, review. You can watch the body camera videos again. You can watch anything you want to, look at any pictures you want to. You can go through Mr. Frederick's report, anything you want to, as you work together in the jury room to reach your decision. We learned through the beginning of trial that University of Cincinnati Police Department and the University of Cincinnati Police Department and the Cincinnati Police Department had a mutual aid agreement. We know that that meant that the defendant could patrol not just on UC's campus, but also outside into the city. And we know from the evidence that's been put forth that the defendant was actually not on UC's campus, but outside in the city of Cincinnati. And in fact, his own testimony was that he was a little bit outside of his beat or the area that he was assigned to cover that day. This is all just a little bit of a piece of the information that we put together to try to get a complete picture of what happened on July 19th of 2015.
9233 traffic stop. I'll be on Phil Street, just off of Vine.
You are Mill Street?
Hey, bro. So, just off of Vine. Okay, we're supposed to stop. We're on White Street, just off of Phil. George Lincoln there, 6917. I saw that one. Hey, how's it going, man?
Hey, how's it going?
Good, Washington, DC Police. Do you have a license on you?
Yeah, what happened? What are you talking about?
Is this your car?
Yeah.
Let's send back to the female, actually.
My wife, her name is Sean DeVries.
Okay. We don't have a license plate on the car.
Oh, that's what my girl about. I have it.
What's that?
It's right here.
Oh, okay. Yeah, that's not go where the front plate's supposed to go. You don't have to reach for it. It's okay. You have a license on you?
Yeah.
What's that about on the floor there?
Valid
About a what?
plate.
Okay. Do you have a license on you? Okay, do you know what that license had? Is that, or what?
I got my values and stuff on that.
Okay, I'm gonna ask you again. Do you have your license
I
on you?
have license. You can take one of my name.
So do you not have the license on you? I'm asking you a direct question. Do you have your license on?
I thought I did. I understand. What did you pull me over for?
Again, the front tag.
Is it an accident?
But it's not illegal to have a front flag. It's just
Okay. Actually, I'm gonna ask you again. Do you have a license on
I
you?
have a license. You can run my name.
Okay. Is that not on you then?
I don't think I have it on.
Be straight up with me. Are you suspended?
Yeah, I'm not remember.
You know if you have your license on you.
I just remember. I'm sorry, sir. I'm gonna go in the house.
Okay. What do you say, down
Right
here?
around the window.
Okay. So, I thought I could figure out if you have a license or not. Go ahead and take your seatbelt off for
I
me.
didn't even do that, man.
Go ahead and take your seatbelt off.
After the defendant shot Mr. Dubose in the head, an investigation began. At that point, we know from the evidence and the witnesses that the Cincinnati Police Department decided they would investigate the events that led up to the shooting of Mr. Dubose. Criminalist Horning testified that she came in and that she was there for many, many hours measuring and getting measurements from the scene. You'll have this along with the entire body-worn camera video back in the jury room with you. But she did the measurements and she said because everything was moved at this point. The cars were moved, the defendant's car was moved, Mr. Dubose's car was up the street, that she picked a fixed point to all her measurements. So these are the measurements that she was able to get way later after the incident occurred. Just another piece in the puzzle as we try to work through what happened on July 19th. As I read to you in opening, an indictment was issued. The indictment for count 1 said that on July 19, 2015, in Hamilton County, state of Ohio, the defendant purposely caused the death of Sam Dubose. Each one of these are the elements that the state of Ohio needs to show you that it happened in Hamilton County, that it was on this date, that it was purposely, and Mr. Sam Dubose was killed as a result of it. What does purposely mean? It has a long legal definition which the judge will give to you, but some of the points are that a person acts purposely when is their specific intention to cause a certain act. To do an act purposefully is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act or brings about a result is determined by the manner in which it is done, the means or weapon used, and all the other facts and circumstances. The defendant acts purposely when it is his specific intention to cause a certain result. If you shoot a firearm within 2 feet of a person's head, you will likely strike and kill them. Purpose is a decision of the mind to do an act with a conscious objective of producing a specific result. In the statement given by the defendant after this happened, he told you that he intentionally shot Mr. Dubose in the head on July 19th. Just another piece as we work together to figure out exactly what happened on Wright Street. Deadly weapon. A deadly weapon means an instrument or device capable of inflicting death. We had Kevin from the lab come in, and he went through in great detail about a gun, how it works, and all those things. A firearm is any deadly weapon capable of expelling or propelling one or more projectiles by the action of explosive or combustive propellant. Again, he came from the lab, he walked through us in great detail how a gun works, he showed it to us, held it up, I would pull it out, but I'm sure you guys have an opportunity to look at it in the jury room if you'd like to. He walked through, and we know that on July 19th, that's the gun that the defendant used to shoot Mr. Dubose in the head. We know from the lab individuals also that the bullet and casings from the scene match the firearm issued to the defendant. We also know that the fragment from the autopsy was such a small fragment, and you'll have that back in the back too with you, that was recovered from the head of Mr. Dubose was so small it was unable to be matched to the bullet. This is just a picture of the scene that night. Obviously this picture is much later because this all happened about 6:30 in July, which was a sunny day. Count 2, as I told you to open, is a little more complicated. Count 2 is voluntary manslaughter. The state needs to show that on July 19, 2015, in Hamilton County, state of Ohio, the defendant knowingly caused the death of Samuel Dubose while the defendant, Raymond Tenzing, was under influence of a sudden passion or in a sudden fit of rage, either of which was brought on by a serious provocation occasioned by the victim that was reasonably sufficient to incite the defendant into using deadly force. Knowingly. A person acts knowingly regardless of purpose, when that person is aware that a person's conduct will probably cause a certain result or be of a certain nature. Proof of motive is not required. You don't have to show the defendant's motive. The state doesn't need to show you his motive for this. You just have to say that he knowingly fired the gun that discharged the bullet that struck Mr. Dubose in the head and killed him on July 19th. A defendant acts knowingly when he's aware that his conduct, in this case shooting someone in the head, will probably cause a certain result, in this case death. Kevin Laddick from the coroner's lab testified that the gun was anywhere from 1 foot to 2 feet from Mr. Dubose's head when the defendant pulled the trigger, releasing the bullet that struck and killed him. Just another picture of the scene, another one obviously at night, and this just shows you, and it's hard to capture it in pictures. So fortunately you were all able to go out to the scene and really view it and see it, because the way the scene happened, where it is at the bottom of the hill, when you go up the hill and there's a little curve in it. So it's difficult for the criminalist to really capture the entire scene in a photo. This is just an example of how the scene looked many hours after the shooting occurred. Just another piece of the puzzle as we try to piece together exactly what happened on July 19th. Reasonable doubt. A doubt based on reason and common sense. Not mere possible doubt, because everything relating to human affairs or depending upon moral evidence is open to some possible or imaginary doubts. I always try to ask juries to hold us to that standard. Reasonable doubt. Don't because of all possible doubts or some imaginary doubt. Just hold us to the standard of reasonable doubt. The judge will give you the exact instruction on what reasonable doubt is, and I want you to hold us to that standard. Don't go higher, start thinking of different things. Hold us to the reasonable doubt standard. Direct evidence. Direct evidence is testimony by a witness who has seen or heard facts to which he or she testifies. In this case, it would include all the exhibits and all the agreed or stipulated facts. So again, all these items, and there's a lot of them that you'll be able to go back and take your time and go through each one of them. Review them. Watch the videos. Look at everything. And you'll be able to reach a verdict in this matter. Circumstantial evidence. Circumstantial evidence is evidence. Evidence may also be proved by inference. Evidence may also be used to prove a fact by inference. This is referred to as circumstantial evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other reasonable facts or conclusions. In this case, none of us directly saw the car strike this, but we can infer from the damage that occurred to these cars, to this beams on the side of the road, that the car that Mr. Dubose, when it took off from the scene, caused that damage. In criminal cases, direct evidence and circumstantial evidence are equal. They're equal. So direct evidence and circumstantial evidence are equal. Just another piece of the puzzle as we work through the evidence to reach what happened on July 19th of 2015. In this case, we had several expert witnesses. We had Brett Fredericks, Scott Hogue, Scott Roeder, and I forgot to ask his name, Scaling. But in this case, I think the evidence has shown that not all experts are created equally. For Mr. Roeder, he testified, this is his first time testifying as a forensic video expert. He kept stating that he used human factors and common sense. However, when I asked him, he said he was not a human factors expert. He did not provide information pertaining to how he reached his conclusions. He admitted during my cross that his timing was not correct. He said, oh, it might be off a millisecond or two. When in a case like this, milliseconds matter. He also stated that the car started moving at 2.4 seconds before. He said 2.4 seconds before the shot was fired. Another thing that Mr. Roeder said that was curious is that, and you can watch the video, he stated that this car right here, only from the other angle, was stopped. When you watch the video, that car was not stopped, and you can have your brake lights on without stopping. You're braking, you're slowing. When I pressed him on the issue, he insisted it was stopped. Watch the video. Make your own determination. Then we had Scanlon. He's retired after 33 years with the Columbus Police Department. When crossed by Mr. Teeger, he stated that he had shot 3 people during his tenure. Now he travels around testifying police officers who have shot citizens in an effort to help their cases. He questioned Chief Hughes' training, and he said he'd been training since 2000. And we know in his training, he told them, was to use one of his slides. He said it's a cute little slide, but just to get across the point, never reach into a vehicle. This is just a picture to go back to a lot. From the video, everyone's been trying to figure out exactly where, because a lot of what you see in the background of the video, because this is later that evening, the car is still in the same place, and some of the shots you can see the stairs there, you can see the car underneath it, and other things that you can see in the video when you take it back to the jury room and review it again. just another piece of the puzzle as we work through what happened on July 19th of 2015. Justification. The defendant maintains his use of force was justified because he feared that the actions of Samuel Dubose would cause death or serious physical harm to himself. And if justification is used, then he may use, if he reasonably believes that such force is necessary to defend himself from the actual use or imminent use of physical force by the suspect that poses a threat to death or serious physical harm. Meaning that if he really, at that time, thinks, or he is in some type of imminent fear of physical harm, he can use deadly force. However, I submit the evidence has shown that on July 19th, the defendant was not in fear of imminent harm. Serious physical harm. There's several different definitions of physical harm, but basically it's serious. It's serious physical injury that could cause you permanent incapacity, permanent disfigurement, acute pain of such duration that a result is substantial suffering. That's serious physical harm. Reasonableness. What's reasonable? Severity of a crime being addressed. You have to use that as your standard to figure out what was reasonable in this situation. Whether Mr. Dubose was an immediate threat to the safety of the defendant or others. Whether Mr. Dubose was actively resisting arrest or attempting to evade arrest by flight. Whether the officer played a role in creating the dangerous situation that occurred on July 19th. In this case, Mr. Dubose was stopped for a front license plate. He was not an immediate threat to the safety of the defendant or others. Mr. Dubose was not actively resisting arrest, but he did appear to be planning to drive away. And the defendant, Mr. Tenson's action played a significant role in creating this dangerous situation. From when he lunged into the car in an attempt to reach in, turn off the car, and take out the key. All those actions, jump in, reach in, turn off the car, take off the key. And he thought he could do that in a matter of seconds. We're going to walk through the slides that Mr. Fredericks prepared for us. I want you to know that this first slide, which you'll have this back in the studio room if you want to review it again, it's slide 131, and at this time to shot is 2.397 seconds. As you can see, the defendant's hand is just now, his gun hand is just now starting to move off the top of the car. In Mr. Roeder's testimony, he testified at 2.4 seconds, the car was already moving. You can see from this that the car is not moving. At this point, as I said, the defendant's hand is just beginning to move off the top of the car. This is all just another piece of the puzzle as we try to put together exactly what occurred on July 19th. We move on to slide 132 as we're moving closer, 2.356 seconds to the shot. 133. He's starting to reach, the defendant's starting to reach towards the interior of the vehicle. You can see the defendant's left foot planted firmly on the concrete. The car is not moving, 2.266 seconds till the shot. You can see his foot firmly planted on the ground as his hand begins to reach into the car. 135, foot still visible. 136, 2.201 seconds to the shot, foot still planted on the ground. Just another piece as we put together what happened happened on July 19th of 2015. We're walking down. Now you can see the defendant's reflection in the car there. 2.168 seconds to the shot. You see his hand going towards the steering wheel. Still can see his reflection, although it's a little blurry, immersion blur, as we get closer to the shot. Still you can see the defendant's reflection in the side of the car. The car is still not in motion. 2.100 seconds to the shot. Again, still walking through it. 2.070 seconds. You can still see the defendant's reflection in the side of the car. The car has not yet moved. Now, Mr. Fruggs will point out, you can still see the reflection. As you can see, Dubose's hand moves towards the defendant's hand. There's 2.038 seconds to the shot, and this is on slide 141. Just more pieces of the puzzle as we work together to decide what happened on July 19th. Now it's slide 142. You can see just a little over 2 seconds to the shot. You can still see the reflection in the side of the car. There's a lot of immersion blur here, and I believe that this is the slide where Roeder testified that you can see that Dubose has the officer tensing the defendant's hand pinned to the steering wheel. Still a lot more blur at 144, 145. You can see at 1.875 seconds till the shot. In the background, you can see the background hasn't changed. We saw the car earlier there in the background, how it was parked. You can still see the post to the fence, the car, the light under the car. The Honda is not in motion at this point. Just another piece of the puzzle as we figure out what happened on July 19th. At 1.842 seconds to the shot, there's a lot of blur, a lot going on right there. More blur. You can still see, although it's blurry, the defendant's legs in the side of the car. At this point in the tape is where the defendant yells stop for the first time. And that's 1.711 seconds to the shot. I put this in here. This is a screenshot from one of the third stop that the defense put in to show, because I believe Roeder said that that wasn't a reflection, that was a shadow. This is the stop where he handcuffed the gentleman and put him in the car and then ultimately let him go. Well, you can see in his car also, you can see the defendant's legs, the reflection in the car, as well. In this one, you can see his shadow on the ground. So just to show that the reflection in the car, which I believe Mr. Roeder attempted to say was a shadow, a reflection just like in this screen. Just another piece as we figure out what happened on July 19th. At slide 153, we're 1.645 seconds to shot. 154, 1.614 seconds to shot. 155. At 156, which is 1.548 seconds to the shot, you can still see in the background, although it's blurry, you take it back there and look at it, you can still see that the background has not changed. The car has not yet moved. In 157, you can see the defendant's hand as well as Mr. Dubose's hand. You can see that his hand is not on the steering wheel. You can see, and that's 1.516 seconds to shot. His hand is there, free there in close proximity. Free. Just another piece of the puzzle Again, at 1.483 seconds to shot. Although blurry, it looks like the Honda has still not yet moved. It's still in the same place. Remember, Mr. Grover said at 2.4 seconds it already moved. At 1.483 seconds, it still has not yet moved. We walk through. We're still out. At slide 165, you can see two things in the slide. For number one, you can see the defendant's hand is nowhere near the steering wheel. His hand is up in the area of Mr. Dubose's stomach as well as his seatbelt. And you can also see on the ground that crack. The crack that you can see in the video as the defendant is approaching the car. When he's walking to the car, you see a crack on the ground. And you can go back and watch in the jury room. But that crack is still visible there in slide 165, and the Honda still has not yet moved. Here are two attempted still frames. It's easier to see on the video where you can kind of see the crack in the road there. You can kind of see it. I probably should have stopped the video earlier when I played it. The crack there in the road. Just another piece to piece together that this car had not yet moved. The defendant was not being dragged by this car at 1.222 seconds before the shot is fired. At this frame, this is the first image of the gun. And you may remember that Chief Pogue told us, and he doesn't know exactly, he told you that, but from studies he said that they found it takes anywhere from 1 to 2 seconds to pull your weapon. 1 to 2 seconds before we get the same image. Obviously, we don't know exactly how long it takes the defendant to pull his weapon, but it could be more, or it could be less. But we know by this point, the car has not yet moved. You can see the gun, and we're 1.222 seconds prior to the shot. Just walk through the rest of the slides here. 169, you can see, although blurred, you can see the defendant's arm there. You can see Mr. Dubose's arm. They're not connected. It appears in this slide 169 and 170 that the defendant is standing upright. You can see right here, this is his entire arm. You can see the emblem of his uniform. You can still see the SUV in the background. You can see his arm, his shoulders all the way up here. We know the camera is about 13 inches from his eyes. And we can tell at this point, 1.092 seconds from the shot, it appears that the car has not yet moved. Just another piece as we piece together what happened that day. So here, Mr. Froese has told you that the car is not in motion. At 1.059 seconds prior to shot, we can see from those slides that the defendant's left hand was nowhere near the steering wheel. We can see that he was not being dragged up the roadway. We can see that he didn't pull his weapon because he was being dragged, because there's no evidence that he was being dragged. There's nothing to show you that he was in any fear of imminent danger or harm at 1.059 seconds prior to when he shot his gun and fired it into Mr. Dubose's head. At this point in time, the defendant could not have misperceived that he was in motion or being moved. The Honda is not in motion.
So as I reached in to knock the key out and turn the key off, he put it in drive. It was a the center console shifter. He put the vehicle in drive, and he just mashed the accelerator as he pulled out. And my hand and my left arm, it somehow got caught or tangled up in the steering wheel as he's accelerating. At this point, I lost my balance, and I fell against his car on the left side of my body. Was hanging onto the side of his car, and I was kind of facing backwards. My body was facing his trunk as he continued to accelerate. But my arm was still stuck at this point. I could not free it. At that point, I was thinking, oh my gosh, I'm getting dragged by this guy's car. I don't want to die today. I'm in fear of my life. At some point, my hand is still stuck as I'm drawing my weapon out, thinking, this guy's actively trying to kill me right now. I don't want to die today on the street. I don't want to get run over by his vehicle. So I pulled my gun out, and as I'm falling, I'm kind of below the plane of his window. So the only shot I could see that I could take to stop the threat was a headshot. That's the only part of his body I could really see at that point and had a clear visual of. And I was telling him, I told him, I believe twice, to stop the vehicle, stop. I just want him to stop the car. That was my goal. He still just continued to accelerate, and that's when I discharged one round. And I hit him in the head with that round. Again, I did that because I was in fear of my life. I was always...
There you hear the defendant's statement as he describes what is on the photos as we walk through. There's no place on those photos that we saw where the car is in motion, where the defendant was being dragged. There's nowhere on those photos where he's below the plane of the window so that his only shot he could see would be the head. In all the photos as we walk through, you can see Mr. Dubose's entire body. And we know that the body camera is approximately 13 inches below the defendant's eyes. So the body camera's seeing into the car, his eyes are 13 inches, 12 to 13 inches above that. In this picture we see during an interview, the defendant was asked to show where his hand was trapped. During his interview, he started right away with the excuses that he says his hand was trapped there, stuck in the steering wheel. You've walked through the pictures from the video. There's no evidence that's been shown to show that the defendant's hand was trapped in the steering wheel. So then the defendant says he perceived that his hand was trapped in the steering wheel. There's no evidence to show that there's any time for perception of his hand being trapped in the steering wheel. Just another puzzle as we figure out what happened on July 19th of 2015. We had Mr. Fredericks testify and tell us that that entire encounter, I believe that's the right one, from the time when his hand was by the steering wheel to the time that he went to the chest of Mr. Dubose was 0.4 seconds. 0.4 seconds between the movement, and we see here the gun is coming into the picture already. Just another piece of evidence to work through. Take the time, listen to the rest of the defendant's statement. There's several other inconsistencies when you listen to his statement and you watch the video. You'll see several inconsistencies. You also notice that the defendant uses the proper buzzwords. I fear for my life. Stop the threat. All the things that he learned in his training were the necessary keys in a situation like this. Listen to the entire interview and compare what he's saying to what you see on the video.
233 traffic stop. I'll be on Phil Street, just off of Vine.
2 Mill Street?
Hey, from Phil, just off of Vine. Okay, we're supposed to stop. We're on Rice Street, just off of Phil. Ohio, George Lincoln North, 6917. I-501.
As you approach his watch, you can see the line on the sidewalk there.
Hey, how's it going, man? Good, license and UC, please. Do you have a license on you?
Yeah, yeah, I do.
Okay. Is this your car?
Yeah.
Let's come back to the female, actually.
My wife, and then the son to read.
Okay. We don't have a license plate on the car.
Oh, I just come on here about it. I have it.
What's that?
It's right here.
Oh, okay. Yeah, that's gotta go where the front plate's supposed to go. You don't have to reach for it, it's okay. You have a license on you?
Yeah.
What's that bottom for you now?
Bottom
Bottom what?
what?
Okay. Do you have a license on you? Okay, do you know that license had, is that, or what?
I got my father's stuff on that.
Okay, I'm gonna ask you again. Do you have your license
I
on you?
have license. You can take one of them.
So do you not have your license on you? I'm asking you a direct question. Do you have your license on?
I thought I did. I hadn't seen it. What did you pull me over for?
Again, the front tag.
Is it an accident?
But it's not illegal to have a front flag. It's just
Okay. Actually, I'm gonna ask you again. You have a license on
I
you?
have a license. You can run my name.
Okay. Is that not on you then?
I don't think I have a number.
Be straight up with me. Are you suspended?
Yeah, I'm not remember.
Why don't you have your license on you?
I just don't know. I'm sorry, sir. I'm from the Golden House.
Okay. Where do you stay at? Down
Right
here?
around the corner.
Okay. So I thought I could figure out if you have a license or not. Go ahead and take your seatbelt off for
I
me.
didn't even do that, man.
Go ahead and take your seatbelt off.
Dr. Lohman told us that Mr. Dubose died instantaneously. The bullet traveled left to right, backwards and downwards. The bullet transected the brainstem and Mr. Dubose could no longer control his body. She told us that gravity would have taken over, and from the rest of the video we know that his foot fell onto the accelerator, the car took off up the street, and when the defendant approached the car later, the car was still revving, because Mr. Dubose's foot, as he lay there dead, was on top of the accelerator. The car is still revving, until the defendant reaches in and turns it off. Some of the debris, picture obviously taken much later. A picture, as I told you earlier, it's difficult, these pictures, to capture the scene, but luckily you all got to go out there and look at it, see what it's like. Chief Hogue told us that during this traffic stop, it may have been advisable just to de-escalate the situation. When Mr. Dubose offered to give him his name, get his name from him. You still can go forward with all the things that the way you want to do your traffic stop. Just let him tell you his name. And then proceed to tell him, all right, I'm going to take you out of the car. De-escalate the situation. Don't escalate it and let it turn into the events that happened to July 19, 2015. As jurors, we just ask you to use your common sense, and as we all know, common sense sometimes can be the rarest sense of all. We heard Mr. Rover say that he used common sense to reach his decisions along with human factors and so forth. I want you to use your common sense An expert should be able to tell you something different. Don't use his common sense. Use your own common sense, which you would use in your everyday life. Work together as a group. Look at all the evidence to put the puzzle together. I pulled these couple of screenshots from Officer Kidd's video, body-worn camera video, to show the defendant testified that, or Officer Asbury testified that the defendant said he had no idea that Mr. Dubose was dead. But if you look at, and you can go back to 2:30 on Officer Kidd's video, you can see the defendant looking into the car. He told Mr. Teager he never checked on him, he never checked his pulse, he never asked if he was okay, but yet he wants us to believe that he had no idea after he looked into that car that Mr. Dubose was dead. Just another piece as we piece together what happened on July 19th. We ask that once you work through all the evidence, once you look at everything, that you come back and you find that defendant, Raymond Tenzing, guilty of murder. Thank you.
Mr. Matthews.
Thank you, Your Honor. May it please the court, Mr. Graffenreid, Mr. Teager, ladies and gentlemen of the jury. We are now at that stage of the proceedings known as closing arguments, which you all obviously realize. Judge Giz will tell you in her instructions, which she will give to you, about the law that applies to this case after I finish, after Mr. Teager finishes, that closing arguments, just like opening statements, are not evidence. This is simply our opportunity to sum up for you what we think the evidence has either shown or has failed to show. Opening statements were designed to assist you in giving you a little roadmap as to where we thought the evidence was going to take us. Closing arguments are designed to attempt to tell you what we think where the evidence is taken. I asked you when we started doing voir dire, I asked you if you would all commit to me that if I did anything during the course of this trial or said anything during the course of this trial that offended you or made you mad, that you hold it against me and not hold it against Ray Tenzing. I'm going to ask you to renew that commitment right now. If I've done anything during the course of this trial, or if I say or do anything during the course of my closing argument, please don't hold that against Raymond Tenzing. Decide this case based on the evidence that's been presented in the courtroom. You know, this case is a terrible tragedy for everybody that's been involved. You've had the opportunity, as you've sat here, to watch the Dubose family who've been present throughout the trial on that side of the courtroom. You've been able to observe the Tenzing family who's been present in the courtroom on this other side of the courtroom. And I think you can see the terrible emotional reaction that they've all had in this situation. You know, Mr. Teager on Friday afternoon asked Ray Tenzing, "Do you ever think about this?" Ray told him, "I've thought about it every moment for the last 2 years." He has been impacted tremendously by this, just like all the families. When I was in school, ladies and gentlemen, I took math. I wasn't the greatest math student, but I did all right. And one of the things we studied were equations. You have one side of the equation and the other side of the equation. And in order to figure out the answer to the problem, you had to understand each side of the equation. We've spent the last, I don't know how long, it's been 2 weeks now, talking about the Ray Tenzing side of the equation. Mr. Graffenreid, in her opening portion of their closing argument, just told you everything about Ray Tenzing. And that's appropriate because the state of Ohio has the burden of proof in this case. They have to show either the offense of murder or the offense of voluntary manslaughter by proof that convinces you of the truth of these charges beyond a reasonable doubt. And Judge Giz is going to define reasonable doubt for you at the end of the case. But in order to get there, they focused on what Ray Tenzing did. And I would submit to you, and again, we have raised what's called an affirmative defense, the defense of justification. We're saying that Ray Tenzing, and he's never denied that he intentionally fired the shot that killed Sam Dubose. He has denied that his purpose was to cause the death of Sam Dubose. He's always said, my purpose was to stop the threat that I felt Sam Dubose posed to me, to my well-being. In any event, my feeling is, ladies and gentlemen, that in order to establish the defense of justification, Judge Giz is going to tell you, we have to prove that by a preponderance of the evidence. And she's going to define preponderance of the evidence for you, just like she would define reasonable doubt. I've seen some lawyers give an example of proof beyond a reasonable doubt. If you've got scales, to prove something beyond a reasonable doubt, you have to tip that scale like that. Whereas with a preponderance of the evidence, you just have to merely tip the scale a little bit in favor of whichever side you're advocating. 51% gets you the preponderance of the evidence. It's a lesser standard than proof beyond a reasonable doubt. Having said that, ladies and gentlemen, I hate to go back through all the facts over and over again because you've heard them over and over again from all these different witnesses, but I feel my obligation to Ray Tenzing is to go through this, but to look at it from the perspective of Sam Dubose. Mr. Graffenreid told you that one of the factors you have to consider in determining whether Officer Tenzing was justified in his actions was whether or not he contributed to this situation, what he did. Well, I think we also have to look at Sam Dubose, and we also have to look at DeShonda Reed. Remember, DeShonda Reed was the second witness who testified. And DeShonda testified that she was, what did she say? She was the mother of 3 of Sam's 13 kids. She was his fiancée for 2 days. The car that was involved in this case was DeShonda Reed's car. She is the one who apparently purchased the car, had it titled in her name, and did not put a front license plate on it. She also allowed her own license to become suspended for some incident that she was involved in Springdale, and she was allowing Sam Dubose to drive her car with her license being suspended. Now, how does that factor into this case, ladies and gentlemen? Well, we know that Ray Tenzing was sitting there at East Hollister and Vine Street on July 19th when Sam Dubose comes down the hill from the direction of the UC campus without a front license plate. You may feel like, as the prosecutor in this county said, stopping somebody for no front license plate is a chicken crap reason to stop somebody. But I would submit to you, ladies and gentlemen, that no matter what you think about the front license plate law, it is the law in the state of Ohio. Ohio requires that you have a front license plate. Every year the legislature, I think, considers bills to do away with that requirement, and it never passes. The law in Ohio is that we have to have a front license plate on your car. And when you don't, you're fair game to a police officer out there. They're required to enforce the law, and that's what they do. That's what drew Ray Tenzing's attention to Sam Dubose, but that's not why he stopped him. You saw on the video, and you'll have an exhibit that shows what he did with his computer on his in-car computer, his in the cruiser computer. He punched in the license plate that was on the rear of that car, and it immediately came up and told him the registered owner of this car, DeShonda Reed, is under suspension. So what did he do? He initiated a traffic stop. Why would he initiate a traffic stop? Well, for a couple of reasons. Number one, driving under suspension is a much more serious offense in the state of Ohio than not having a front license plate. Number two, Ray Tenzing had been hired at the University of Cincinnati Police Department because they had a crime problem around the campus. You heard testimony. They greatly increased the size of the police department. They brought in a police chief who created what one officer referred to as a blue line or a no-fly zone. The objective was get out there and enforce the traffic laws, let the bad guys know we're out here because we're tired of them bothering and molesting and robbing and beating our students and causing problems around our campus. So if the word gets out that the police are out here, the UC police are out here enforcing laws, maybe the people will take their intention somewhere else in the city. From what we know, the the city of Cincinnati did not have enough police to patrol in that area full time, all the time, and that's why UC entered into this agreement to patrol the surrounding areas around the campus, and why they hired extra police officers. And what do we know from, I think it was Lieutenant Barge, the first witness who testified, and maybe a couple of the other UC officers? The program was working, crime was down, because UC officers saturated the area. The powers that be, and Chief Goodrich is the one who allegedly created this no-fly zone or blue line, but I would suggest to you that Chief Goodrich was taking his orders from somebody higher up in the UC administration. But those orders were passed down through the command staff to the patrol officers like Ray Tenzing. They were told to go out there and get traffic stops. And remember, I think Lieutenant Haas testified the other day. He said that he thought that the traffic stops were getting out of hand, were making way too many of them. And Chief Goodrich was right behind him telling the officers to go out and get more. Ray Tenzing was doing what he was instructed to do on July 19th. During the course of the trial the other day, just so you had a full picture of what Ray Tenzing was doing on July 19th, I played 3 body-worn camera videos that were made before his contact with Sam Dubose. And I played those for a number of reasons. The first video was just to show you that he went to work that day. I wanted you to see everything he reported that day. The first video was him backing up another officer on McMillan Street. And there wasn't much we could tell about that video. It was rather short. The traffic stop was concluded and Ray went back to patrol. The second video on there, which was the one which was about 35 minutes long, it was the husband and wife with 4 kids in the back seat, also on McMillan Street. The reason I wanted you to see that, ladies and gentlemen, was because that showed a number of things. First and foremost, the reason Ray Tenzing made that stop on that car was that it had no front license plate, the registered owner was under suspension. When Ray Tenzing approached the driver of that vehicle, what happened? The driver produced a state identification card, and he readily told Ray, "I'm under suspension." At that point, Ray asked him, Ray said, "I'm going to get you out of the car, I'm going to detain you." And Ray handcuffed him in the car. And I wanted you to see that handcuffing the car technique, which we heard some testimony about. It's a valid technique. It's one that Ray Tenzing used. It's one that he testified that he intended to use with Sam Dubose. It's not something that he just made up on the spur of the moment to justify his trying to open that car door. He intended to handcuff Sam in that car, and in order to do that, you have to open the car door. Well, what did he do? He got the gentleman on McMillan Street out of the car after he handcuffed him. The first thing that happened was the fellow got out of the car and indicated that he was uncomfortable. And what did Ray do? He adjusted the handcuffs. He didn't have to do that, but he adjusted the handcuffs to make them more comfortable. He told the individual, "I'm going to take you back and put you in my cruiser so you're out of traffic and it's more safe." He got him back to the cruiser. He turned the air conditioner up for him. He didn't have to do that. You know, Mr. Teeger Friday tried to inject racism into this case. Blatantly tried to inject racism by suggesting that Ray Tenzing is a racist. If Ray Tenzing was a racist, he wouldn't have fixed the man's handcuffs. He wouldn't have put him in air conditioning. But what else did Ray do in that step? He went back to the car. He gave the man's wife the keys to the car and said, "While I'm busy with him, turn the car on, turn the air conditioner on for you and the kids." What else happened? Well, in that traffic stop, Ray Tenzing quickly became aware that the driver not only was under suspension, but he had 5 open warrants, meaning he hadn't shown up for court 5 separate times. Ray at that point had the option. He could have locked that man up and taken him to the Justice Center. He could have towed the car, and he could have left that family stranded on the side of McMillan waiting for somebody to come get it. But remember when he told the lady, "You can turn the car on and the air conditioning on for the kids," call somebody that's got a valid license to come pick you and everybody up and take this car, because I can't let an unlicensed driver drive it. And the lady was also under suspension. So what happened in that stop? Well, and then we skipped through a lot of it because the bulk of it is Ray sitting in his cruiser filling out a new citation for the individual. Rather than locking him up and taking him to the Justice Center, he gave him another ticket. Said, here, this is for the 5 times you didn't show up in court. Here's a new court date. Go take care of this. He also cited him for driving under suspension and not having the children in child restraint devices. The point is, everybody went home from that traffic stop. The car didn't get towed, the man didn't go to the Justice Center, and the family didn't get stranded on the side of McMillan. Ray was polite and courteous throughout the entire stop, and there were absolutely no problems. Okay, let's skip forward to 5:58 that afternoon. Ray once again activates his body camera. Remember, he has to physically activate that camera by punching it 2 times. He doesn't have to turn it on if he doesn't feel like it. He's supposed to by policy, and he did. But if he was going to go out, his intention was to kill Sam Dubose, I don't believe he would have turned that body camera on. He created a video, and he did. In any event, the stop in Bellevue Park. Again, why did he make that stop? Well, he sees a car with no front license plate, punches in the license plate that's on the rear of the car, and lo and behold, the registered owner is suspended. Just like the stop on McMillan, just like Sam Dubose. What happened in that incident? Well, you saw it. It lasted less than 5 minutes. Ray approached the car, polite, courteous. And what did he do? The girl driving the car presented him with what appeared to be a valid Ohio driver's license. The man she was with provided Ray with what appeared to be a valid Ohio driver's license. He took those licenses, he went back to his cruiser, ran them through the computer. There was no problem. He gets out, returns them to the people, and says, have a nice rest of your day, and by the way, I'm going to just give you a warning for the no front license plate. He could have given that lady a ticket, even though it wasn't her car, she was driving. He didn't give her a ticket. He said, here's a warning. Get the license plate on the front of the car. Have a nice rest of your day. And the girl said to Ray, you too, officer. And then Ray and his fellow officer who showed up to back him up talked about having dinner at 6:45. Now, why is that significant? Well, it's significant because the voluntary manslaughter charge that Mr. Gravenry just had up here on the TV screen. It's a little more complicated than the murder charge, but it talks about factors of sudden influence of, or under the influence of sudden passion or a sudden fit of rage. There's no evidence up to this point of anything in Ray's day on July 19th that showed that he was in anything other than a fine mood. He wasn't under any sudden passion or any rage. Fast forward from the stop in Bellevue Park. A half hour later, less than a half hour later, Ray is returning to his beat. He's sitting at East Hollister and Vine Street, and along comes Sam Dubose. Well, Sam Dubose has got something in common with the last 2 stops. He's got no front license plate, and the car is registered to someone who's under suspension. Ray initiates a traffic stop. They go down Vine Street, down to Phil. Ray has known that Phil Street by Inwood Park there's been a memo put out. That's a bad area. But Ray decides, I'll initiate the traffic stop. He starts to light up Sam Dubose, but with his overhead lights on his cruiser, but Sam turns on to Phil Street. No concern at all there for Ray. In fact, that's a good thing, because Sam is taking Ray Kensing out of traffic on Vine Street, onto a side street. But what did Sam do at that point? He didn't pull over right away, as you would expect most people to do. Ray thinks, well, perhaps he doesn't know him behind him. He hit the yelper on his siren. Sam continues on. Again, Ray hits the yelper on his siren, and you can hear it in the tape. Finally, Sam pulls over. Ray indicates to his dispatcher, we're slow to stop. Officers Kidd and Lindenschmidt hear that on the radio. And because they know slow to stop is a signal that maybe something's not just right here, Ray Kensing testified. That began to get Ray some red flags for me. So, Kidd and Lindenschmidt decide they'll respond down there to back Ray up. Ray initiates the traffic stop. Sam finally pulls over right on Rice Street. And I think the evidence is, and I think you can tell from the body camera video, he stopped his car, Sam Dubose stopped his car with the front edge right on the northern edge of that driveway, on the house on the corner. It wasn't blocking the driveway, it was right before the driveway. And that's going to be significant. Ray Tenzing gets out of his cruiser, approaches Sam Dubose, polite and courteous, just like he was on every other stop he made. He asks Sam for his identification. Do you have a driver's license? He asked him, and you just saw it played twice for it. He asked him on multiple occasions, in one form or another, do you have a driver's license? Sam never responded. He said, well, he did respond. Yes, I have one. What, do you have it on you? Yeah, well, no, maybe I don't. He's feeling around his pockets. What do we know? We know, number one, from Dr. Lohman's testimony, that Sam, in his pocket, had a state-issued identification card, just like the fellow at the traffic stop on McMillan. We know, and Ray knew, when you have a state-issued identification card, you don't have a driver's license. You can't have both. Why didn't he have a driver's license? Well, was he under suspension? Probably. Did he just never get a license? Maybe. We don't know that. All we know is that Sam Dubose did not have a driver's license, and for one reason or another, he didn't want Ray to know that. We also know that he didn't want to produce the identification that he had on his person because he knew immediately that Ray Tenzing would know that there was an issue with his driver's license, and that wasn't going to end this traffic stop. But during all this discourse back and forth, a number of things occurred. Why did you stop? Well, you don't have a front license plate on your car. Well, I got one right here. It's in the glove box. So he opens it, takes the keys, turns the car off, takes the keys out, opens the glove box, and Ray says to him, don't worry about it. It doesn't go there. It goes on the front of the car. And Sam asked him again at one point, why did you stop? And Ray told him, I told you before, you didn't have a front license plate. And Sam wants to argue with him. Well, it's not against the law in Ohio to not have a front license plate. Ray said, well, actually it is. And it is. We know that. Ray didn't tell him because the car's registered to somebody who's under suspension, and Ray told you, the reason I don't do that is because I want to see whether they're going to be honest with me. And that was a test of Sam's honesty. And Sam failed that test miserably, by the way. Remember, Ray asked, who owns the car? He said, my wife owns the car. And DeShonda Reed. Well, DeShonda wasn't his wife. We know that. But that doesn't matter. That's not important. During Ray's few seconds that he's dealing with Sam here, he notices on the floorboard between Sam's legs a bottle. Ray doesn't know what it is exactly, but he sees that bottle between his feet. He says, what's that? And Sam hands it to him. And it's a bottle, and you've seen it. It's clearly marked Jim. And Sam said, and I don't know if you can hear it in here, but you'll have this tape back in the jury room where I think the acoustics may be a little better. But Sam said it's air freshener. Well, why is somebody driving around with a bottle of gin that's got air freshener? That's what Ray wanted. Unlike the license plate, which was in the glove box, which Ray said, I'm not worried about it. Ray took that bottle of gin when Sam handed it to him, and he put it on the roof of the car. Mr. Graff and Reed talk about inferences you can make. I think you can infer from the fact that Ray Tenzing put that bottle marked gin on the roof of the car. You can infer from that that Ray intended to come back to that to figure out what in the world was going on with this. Do I have an OBI situation here? Is he under the influence of drugs or alcohol? Or why would he be carrying air freshener in a gin bottle? Well, Ray told you, and you heard from other officers that testified. Sometimes people who are transporting drugs carry air freshener in their car to mask the odor. Perhaps to throw off the scent of a drug dog if a drug dog gets called in to sniff around in the car. In any event, the bottle of gin's on the on top of the roof of the car. Ray Tenzing says something to the effect that we just saw it, you'll have it. Until I can figure out who you are, go ahead and take your seatbelt off. And at the same time, he's reaching to open the car door. What was going on there? Well, Ray is going to put Sam in handcuffs just like he did with that driver up on McMillan Street. Before he gets him out of the car, he's going to detain him until he can figure out who he is and what he's up to. And by this time, he has seen all kinds of signs that raise red flags for him as a curious police officer. When Ray opened that car door, or started to open the car door, what happened? And again, Mr. Graff and Reed showed you slide after slide from Grant Frederick's presentation. And I would ask you, I want to stop here for a minute and ask you, or advise you, you'll also have slides back there which we made frame by frame, taken from the video, that don't have all the little curves and curly cute cutouts. And I think they probably, some of them show a little more, maybe not in as clear detail as Grant Frederick's slide, but they show more detail. Because I believe some of those slides from Grant Frederick's are minus some of the details on the edges. But in any event, Ray Tenzing, when Ray Tenzing started to open that car door, and again, Mr. Graffenreid kept referring to what Ray Tenzing was doing. Watch in those slides also what Sam Dubose is up to. Watch his movements in motion. Sam Dubose, as he starts to open the car door with his right hand, somehow has gotten back a hold of the keys and puts those back in the ignition. And he starts the car up. And he drops immediately his hand to the center gear shift in the console and drops it into drive. With his left hand, after he finishes pulling the car door shut, that's when Ray Tenzing decided, I think I'm close enough, I can knock those keys in. That was a mistake that Ray Tenzing made, no question about it. But you've heard testimony from everybody, every police officer who testified here, that this never reach into a vehicle is a myth. Officers do it all the time. And maybe it is a bad tactic. Maybe it's not recommended. But even the OPATA manual says that if you're going to reach in a car, do it with your non-dominant hand. Don't reach in with your dominant hand. To me, that implies, you probably shouldn't reach in, but if you do, use your non-dominant hand. It doesn't say it's illegal to reach into the car or you can't ever do it. And officers do it all the time. Even Scott Hughes, who produced that slide, told you that he's done it. And he knows it happens across this country all the time. Every day, or not every day probably, but probably at least once a month, you can read about an officer who reached into a vehicle and got dragged. Scott Hughes even told you the story of Kevin Cran, the Cincinnati police officer, a 25-year veteran who reached into a car and was dragged to death. And he wasn't dragged to death. He fell off of the car after he shot and killed the driver of the car, a 12-year-old boy. And when he fell off, he hit his head on the pavement and bounced up, was hit by a tailpipe of a passing car. Officers can get killed by being dragged. So, we've got Sam Dubose with his left hand putting it over the top of Ray Tenzing's left hand, which is in the car at this point. And ladies and gentlemen, I submit to you, despite what you've been told over and over again, that Ray Tenzing's hand was never pinned. And Ray said he thought his hand was caught in the steering wheel. And it wasn't. It's obvious it wasn't. But I think it's pretty clear on those slides, maybe not clear, crystal clear, because it's blurry and there's movement. But you can see Ray's left hand pinned up against that steering wheel. And ladies and gentlemen, at that point, Sam Dubose is mashing that accelerator. And what did he have to do? He had to turn the car to the left to avoid Alicia Napier. Grant Fredericks talked about forward movement. There's no forward movement. Mr. Graffenreid said over and over again, 1.1 seconds, no forward movement. 2.4, no movement. The car's not in motion. Well, ladies and gentlemen, that car had to turn to the left too. And I think you can look at those frame-by-frame slides, and you can see that car is getting closer and closer to Ray Tenzing. It's turning into him. And Ray said he was dragged. They make a big issue out of it. Well, he really wasn't dragged. There's no evidence he was dragged. Well, in fact, dragging has to start somewhere. Dragging is taking somebody from one position and roughly transporting them to another position. That's my definition of dragging. But dragging has to start somewhere. And I would submit to you that as soon as Sam Dubose dropped that car into drive, and remember DeShonda Reed's testimony that day. She said something to the effect, and I still am not clear what the point of it was, but I think I can speculate a little bit. She said he had to keep his foot on the gas and on the brake at the same time. Why would you do that? Well, I would submit that you have to keep your foot on the gas when you've got the foot on the brake to keep the engine running. Apparently, maybe the engine didn't run real well, and he had to keep giving it gas to keep it running. But in any event, once he lifted his foot off that brake, that car began to move left and forward. Not just forward, forward and left. Ray Tenzing, we know, was standing at the middle of the window at this point when he started to reach into that car, toward the middle of the window from the B post. And you can see on that body camera video that by the time that car is dropped into gear, Ray Tenzing's body is up near the A pillar, up by the front of the car. And it's beginning to turn, and you can see it. You can see it slowly turning, and you can see the car turning into him. And remember Scott Boder talked about the mirror on the side of the car. That's when Ray Tenzing began to lose his balance. And I submit to you, that's when he began to feel like he was being dragged. And then the video goes on from there, and you see him get up the street some 20 to 25 feet later up by the manhole cover. Once that car started moving, ladies and gentlemen, Ray Tenzing yelled, "Stop, stop," twice, and you can hear the panic in his voice as he was yelling, "Stop, stop." Why would anybody, and again, you can draw inferences from the evidence, but would anybody yell, "Stop, stop," at a car that wasn't moving? I don't think so. I think you can infer that at that point, that car was moving, and Ray Tenzing was beginning to go down. And Ray Tenzing felt like his life was threatened, or his physical well-being was threatened. And at that point, he withdrew his weapon from the holster, and he fired a shot at Sam Dubose, and it ended up killing him. Ray told you over and over again, my purpose, and he told the police on July 21st, and he testified in the first trial in this matter, and he testified last Friday. My purpose was to stop the threat. And ladies and gentlemen, had Ray Tenzing said anything different anywhere along the line, I can guarantee you that Mr. Teeger would have pointed it out and made a huge deal out of it. But there wasn't anything. Ray's been consistent since July 21st when he first spoke with the Cincinnati police officers about what he perceived and what happened to him on that day. Now, as Ray drew his weapon and fired, there's one shot in there that I think is critical for you to look at, because we've got testimony from Dr. Lohman, who testified that the bullet entered the left side of Sam's head from an upward trajectory, traveled across his brain, severed the brainstem, and came out at a lower position on the right side of his head. Why is that significant? Well, first of all, it tells me that the gun was fired from above Sam Dubose's head. The bullet also traveled from front to back. So it tells me that Ray Tenzing was in front of Sam Dubose when he fired that weapon. But you also see in one slide that I think is absolutely critical here. When Ray Tenzing fires that weapon, his forearm is up and his wrist is cocked down. And I believe that the evidence supports the fact that at that point he's going down and he's leaning down, and that's why his forearm is up, his wrist is cocked, and he fires down. And if you look at the interior of the car, you're going to see the roof of the interior of the car. Ray's not standing straight up, as Grant Fredericks would have you believe, above that roof. You can see when he first walks up to the car, you can see how much farther above the outside of the roof Ray Tenzing was. When that shot is fired, Ray Tenzing, his camera is down, and he's looking up at the interior of the roof. Ladies and gentlemen, Grant Fredericks wants you to believe that Ray Tenzing was standing up, he was not dragged. But I did, Grant Fredericks and I had a little trouble disagreeing or agreeing about anything other than when I asked him if the sun was shining. He did say he could agree to that. But there were a couple things that Grant Fredericks said that I thought were extremely important. He testified, and well, let me back up from that. The state called Alicia Napier, and I am going to bet that Mr. Teeger is going to talk a little bit about Alicia Napier and say that she was an independent witness who doesn't have any dog in this hunt, and so you got to believe what she had to say. But what did Alicia Napier say? Alicia said she was parked in front of Sam Dubose's car. She was putting her two young kids into the car, getting ready to leave, and that she watched this thing. She saw Dubose pull around the corner, Tenzing pull around behind him. She thought it was what she called a routine traffic stop. I don't think there is any such thing as a routine traffic stop. If there's ever a case that proved it, this one does. But in any event, Alicia was watching first through the rearview mirror in the center of her windshield, and then she quickly changed to watch through the mirror on the outside of her car. And she told you, I'm trying to get my kids strapped in. I'm watching Officer Tenzing is writing something. Then I hear a gunshot. And then Officer Tenzing falls back on the street. And I thought he got shot. And then I hear another gunshot. And then I duck down on the floor. And then when Dubose went by, I made a U-turn and got out of there. And later on, the Cincinnati police tracked her down and got her statement. And that's pretty much what she told me. But what did she tell us? She said, well, I filled in some of the gaps after I watched it on YouTube. And what do we know? What does the evidence show? Well, first off, there weren't two gunshots. Secondly, we know for sure that Sam Dubose somehow had to go to the left to maneuver around her car so he didn't dive into the back of that. We know most importantly, and Alicia said the car hadn't moved when the gunshot was fired. We know most importantly that Ray Tenzing did not fall to the ground right next to Sam Dubose's car where the stop had occurred, which is what Alicia said she saw. We know that Ray Tenzing ended up getting up off of the ground, up by the manhole cover, which was 20 to 25, maybe even as far, according to Kim Horning, the Cincinnati police journalist, 27 feet up the road from the north edge of the driveway. Somehow, Ray Tenzing got up there. We know Alicia Napier was wrong about where he fell into the street. But what do we really know Alicia Napier was wrong about? Well, was the car in motion at the time the shot was fired? Alicia is the only witness who came in here and said the car hadn't moved when that gunshot was fired. We had officers Lindenschmidt, Kidd, Tenzing all say the car was moving when the shot was fired. Jim Scanlon came in and testified Friday the car was in motion when the shot was fired. Chief Hogue, I'm not sure what his end position was. I think initially he thought the car hadn't moved when the shot was fired, but then after consulting with Grant Fredericks, he determined, or he agreed that the car was in motion when the shot was fired. The state is relying tremendously on the testimony of Grant Fredericks. And here's one piece of evidence that Grant Fredericks presented in this case, which I think agrees with everything that the defense has presented. Grant Fredericks testified that at the time that shot was fired, the car was in motion. He says it was less than a second, contrary to what Scott Coder said, but it doesn't matter. The car was in motion. And remember what Fredericks said. The car had traveled approximately half of the width of the driveway. Almost, I think he said almost half of the width of the driveway at the time the shot was fired. Well, how far is it? Well, you'll have, and Mr. Bradley put it up on the screen, we'll have a screen, we'll have this little diagram right here. And it's difficult to see, but I think we need to put measurements on it. And one of the things she did was measure the driveway, the width of the driveway, from the north edge to the south edge. And remember, Sam Dubose was stopped at the north edge. That driveway is 13.5 feet wide. Halfway there is a little bit more than 6.5 feet. Add on to the fact that when Ray Tenzing started to open that car door, he was back from the front of the car, by the middle of the front window, perhaps another 3 to 4 feet. I would suggest to you, ladies and gentlemen, that at the time the shot was fired, the car had moved maybe as much as 10 feet, maybe a little bit more, maybe a little bit less. But there's no question from everybody other than Alicia Napier that at the time Ray Tenzing fired that shot to stop the threat to his life, that car was in motion. Sam Dubose, for whatever reason, said, I'm not sticking around here. And I would suggest to you that Sam Dubose made up his mind that he wasn't going to stick around as soon as Ray Tenzing turned on his police cruiser lights. That's why Sam Dubose took him back into Rice Street and didn't stop on Phil. Remember, during the conversation, Sam at one point said, I just want to go home. I think that's what he said. I want to go home, something to that effect. And Ray said to him, where do you stay? And he said something in effect right around the corner. Well, remember when we went on that view, after you all got out of the bus and walked up the hill, on the way back downtown to the courthouse or wherever you were taken after the view, the bus driver continued southbound on Rice Street. And I think if Mr. Weisker did what we asked him to do, he pointed out the intersection of Rice and Winkler Street. And remember DeShonda Reed when she testified, she said that Sam Dubose had a cousin who stayed on Winkler Street. And I would submit to you that that is probably where Sam Dubose was headed on July 19th. He was headed to his cousin's house. Or maybe he was back and took Ray Tenzing back in that neighborhood, figuring this is a neighborhood of narrow streets and there are a lot of side streets and maybe I can lose him, but I'm not sticking around. And why wasn't he going to stick around? Was he concerned that he was going to get a ticket for no front license plate or for driving under suspension? I doubt it. What do we know? Well, we know that besides having a state-issued identification in his pocket, which we learned from Dr. Lohman, we also know that he had some bags of marijuana in his pockets, and he had $2,620 in cash in his pockets. And we also know from the inventories that Officer Pham wrote up after he searched the car, we know there was more marijuana in the car. Ladies and gentlemen, I think you can safely conclude that Sam Dubose had a great motive to get away from there, and he, from the moment Ray Tenzing turned on his police cruiser lights, didn't intend to comply or stop for Ray Tenzing. Brian Scouton, I believe he's the man from the coroner's office who weighed the marijuana, and he told you in his testimony that there was enough marijuana, all he did was weigh enough marijuana to get up to the highest criminal charge he could have gotten, which was more than 200 grams. That takes him up into a felony level. Well, ladies and gentlemen, I would submit to you that Sam Dubose knew that he wasn't going to go home from that traffic stop if he allowed Ray Tenzing to continue his investigation and discover that marijuana. He had a felony quantity of marijuana on his person and in his car, and he would have been locked up and taken down here to the Justice Center. Add to that, ladies and gentlemen, the fact that we don't know, because the toxicology report, which was part of the coroner's report, is not before you in evidence, but we don't know whether Sam Dubose also might have been subject to a charge for operating a vehicle under the influence. We do know from Dr. Lohman that Sam Dubose was not a well individual. We know from the inventory of the car that there were 22 separate medications besides the marijuana found in that car. 6 prescription, which would leave, 16 holistic kind of medications. Something was wrong with Sam. And I think when you combine all those things, you can conclude that he had a motive. I ain't sticking around here for this UC cop. I'm getting out of here because I'm not going to the Justice Center. For that reason, he elected to start that car, put it into gear, and take off with Ray Tenzing's arm trapped inside there. They keep saying, well, Ray could have de-escalated the situation. And I agree, Ray could have de-escalated the situation, except that his arm was pinned up against that steering wheel. And by that point, Sam Dubose has got the car in gear and mashed the accelerator, lurching forward, knocking Ray Tenzing off balance. And all Ray could do at that point was grab for that seatbelt, grab for that D-pillar to try to keep from falling off. And he did eventually fall off 20 feet up the road. Ladies and gentlemen, I submit to you that that is a threat on his life, on his well-being. And when Judge Giz tells you what the law is that applies to this case, I think you're going to find that Ray Tenzing was justified in the actions he took that day. Now, before I sit down, I would like to talk a little bit about the law that Judge Giz is going to read to you, because Mr. Graffin did it. And I expect Mr. Teeter probably would say a little something about it too. But count 1 is a charge of murder. Mr. Graffin put some of the things about murder up there. You have to be convinced beyond a reasonable doubt that Ray Tenzing purposely caused the death of Sam Dubose. And purposely is going to be defined for him. Well, what do we know? And Mr. Graffin correctly pointed out, purpose is the same thing as intent. We know that that Ray Tenzing intended to shoot Sam Dubose. No question about that. Ray Tenzing's never denied that. But what was his purpose? Was his purpose to kill Sam Dubose, cause Sam Dubose's death? Absolutely not. Ray Tenzing's purpose was to stop the threat. And if you find that that is accurate, and Sam Dubose died as a result, no question about that, as a result of Ray Tenzing's attempt to stop the threat, But if you find that the attempt to stop the threat was what Ray Tenzing, the purpose was to stop the threat and not to kill Sam Dubose, then the state has failed to meet its burden to prove beyond a reasonable doubt of murder, and the verdict must be not guilty. Mr. Graffinley correctly pointed out voluntary manslaughter is a little bit of a different animal here. It requires that the state prove beyond a reasonable doubt that Ray Tenzing knowingly caused the death of Sam Dubose. And again, I would submit to you that there is no evidence that he knowingly caused the death of Sam Dubose. He knowingly shot Sam Dubose, attempting to stop the threat that he perceived that Sam Dubose, and not only perceived, but that Sam Dubose was actually imposing on Ray Tenzing. That was what he knowingly did, trying to stop the threat, not to kill Sam Dubose. But with voluntary manslaughter, you're also going to hear some language about being under the influence of sudden passion or a sudden fit of rage. And ladies and gentlemen, I would suggest to you that there is not a single, even smidgen of evidence in this case that Ray Tenzing was under a sudden fit of passion or a sudden fit of rage. And for that reason, ladies and gentlemen, alone, I would submit that the state has failed in its burden to prove beyond a reasonable doubt that Ray Tenzing is guilty of voluntary manslaughter. But if you all disagree with my assessment of the situation, you're still not finished, because your deliberations have to be, I would say, at the same time or after you go through and decide whether the state has met its burden beyond a reasonable doubt. At some point in here, you have to factor in our affirmative defense of justification. Was Ray Tenzing justified in what he did on July 19, 2015? Judge Giz is going to read to you definitions that describe what justification is as an affirmative defense for a police officer involved in an officer-involved shooting. And I'd like to run through that with you just for a second. There's a section called use of deadly force. And I'll read it verbatim here as Judge Giz will read it to you. The standard of law to be applied in determining whether the use of deadly force by a police officer is justified is as follows. Deadly force may be used if the officer reasonably believes that such force is necessary to defend himself from the actual use or imminent use of physical force by the suspect that poses the threat of death or serious physical harm. If such circumstances exist, then the officer's use of deadly force is not unreasonable. The test of reasonableness requires careful attention to the facts and circumstances, including, but not limited to, the severity of the crime that the defendant police officer was addressing, whether Samuel Dubose posed an immediate threat to the safety of the defendant police officer or others, whether Samuel Dubose was actively resisting arrest or attempting to evade arrest by flight, and whether the defendant police officer played a role in creating the dangerous situation. Mr. Graffinreed put each one of those things that you're to consider up on that board there. Let's talk about it for a minute. What was the severity of the crime the defendant police officer was addressing? Well, Sam Dubose didn't give Ray Tenzing an opportunity to figure out what the severity of the crime or crimes was that he might be addressing. All we know is he didn't have a front license plate and he probably was under suspension. Ray Tenzing didn't have an opportunity to discover whether he was operating that vehicle under the influence of alcohol or drugs. He didn't have the opportunity to discover that he had a felony quantity of marijuana in that vehicle, because Sam Dubose did not give Ray Tenzing the opportunity to find out. Whether Samuel Dubose posed an immediate threat to the safety of the defendant police officer or others. Well, I would submit to you that as soon as Sam Dubose started that car and dropped it in the gear, he posed an immediate threat to the safety of the defendant police officer. And Ray Tenzing, you'll have with you a DVD that shows photographs of Ray Tenzing at University Hospital. There's no question, Ray Tenzing wasn't seriously injured here. He's got a couple bruises and a little scrape on his knee. He wasn't seriously injured. His uniform had some damage to it. Nothing serious, but the potential was there to be extremely serious. Witness Scott Hughes' testimony about Cincinnati police officer Kevin Grant. That's what could have happened. Fortunately for Ray Tenzing, it did not. The next thing to consider, whether Samuel Dubose was actively resisting arrest or attempting to evade arrest by flight. Well, he wasn't actively resisting arrest because Ray Tenzing had not put him under arrest. He was trying to detain him. But he was actively evading arrest by flight. He took off. He was trying to evade arrest because eventually Ray Tenzing was going to find out what was present in that car and what Sam Dubose was up to, and he was going to arrest him. I don't think there's any question about that. And finally, whether the defendant police officer played a role in creating a dangerous situation. How am I going to address that? We've heard from the witnesses. Ray Tenzing should never have reached into that car. Did that cause this? Well, it had a little something to do with it, but I would submit to you that Sam Dubose's conduct is what started the entire incident. Ray Tenzing made a tactical error, but even the state's expert witness on use of force, Chief Scott Hood, testified that an officer, if he makes a tactical error, he doesn't forfeit his right to be free from harm, from death or serious physical injury. Officers make tactical errors every day. Everybody makes errors every day. Most of the time they don't turn out this bad. But just because Ray Tenzing made a tactical error doesn't mean that he had to suffer the consequences of Sam Dubose's action and allow himself to be run over or dragged or whatever was going to happen. Next, ladies and gentlemen, Judge Giz is going to tell you about reasonableness. She's going to tell you the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene rather than with 20/20 vision of hindsight. The determination of reasonableness must allow for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. The test of reasonableness is not capable of precise definition or mechanical application. The reasonableness inquiry is an objective one. The question is whether an officer's actions were objectively reasonable in light of all the facts and circumstances confronting him without regard to his underlying intent or motivation. When you get back to the jury room, you're going to have a copy of Judge Giz's instructions, and I would ask you to pay close and careful attention to them. We have spent the last 2 weeks approximately, I don't know when we started this, May 25th, when you first came in here to fill out questionnaires. We had sort of a couple false starts and stops along the way, but once we got rolling, we've been involved in this for 2 weeks. Ladies and gentlemen, this is exactly what 20/20 hindsight is. We are talking about 2.853 seconds of action on that video that have led us all to be here for all this time. And remember, I asked Grant Fredericks, that was one of the things I asked him, isn't this what we're doing, is 20/20 hindsight that we're not supposed to do? And Grant's response to me was, this isn't 20/20 hindsight from my perspective, this is forensics. Well, ladies and gentlemen, I don't care what he calls it. He talked about having watched this video multiple times and breaking it down frame by frame, millisecond by millisecond. And if that's not what 20/20 hindsight is, and what we're doing here is not what 20/20 hindsight is, then there ain't no such thing. Ladies and gentlemen, I would suggest to you, and I don't think any of you are police officers or have any police officer training in your backgrounds, but you have to try to put yourself into the position of an officer on the scene of a situation like this and ask yourselves, what would I do if I was in that situation? You know, I asked Grant Fredericks, have you ever seen the movie Sully? I don't know if any of you have ever seen that movie. But in the movie Sully, that's the United Airways pilot who landed the airplane full of people in the middle of the Hudson River. And he was declared a hero for saving all those lives. But then the FAA got involved and they started tearing apart his every action. And I believe it was after 17 attempts, and knowing that the airplane engines were going to stall when they took off, that they determined, they finally, in a simulator, were able to land that airplane safely. I think it was at the Teterboro, New Jersey airport, which was right to the right of where he landed in the Hudson River. They were about to hang him out to dry and take away his hero status for saving all these people when in the investigation, they brought into the investigation itself human factors. What Scott Roeder said you needed to bring into this case. The body-worn camera in and of itself is not the only piece of evidence. You got to put yourself in the position of Ray Tenzing as he was on July 19th, 2015 at 6:31, or by that time maybe 6:32 or 3 p.m., standing next to Sam Dubose's car. And consider what Sam Dubose did that started this whole situation. And I think, ladies and gentlemen, if you do all that, you're going to find Ray Tenzing's actions were justified. He was a reasonable police officer, and that you had no choice but to find him not guilty of murder or voluntary manslaughter. And remember, when you're back in that jury room, you're going to have only 4 verdict forms. One's going to say guilty of murder, one's going to say not guilty of murder, one's going to say guilty of voluntary manslaughter, one's going to say not guilty of voluntary manslaughter. There's nothing else. If you think that Ray Tenzing did something wrong and should be punished for it, but it doesn't arise to the level of murder or voluntary manslaughter, you don't have any other choices. Those are your 2 choices. And I submit that the evidence doesn't arise to the level of either one of those crimes. Finally, ladies and gentlemen, one thing I haven't mentioned in this case. I'm going to refer to testimony that we heard a week ago last Friday from the lead investigator in this case, Shannon Hine. Remember, Shannon Hine came in here and testified that she was the lead investigator from CIS, from the Homicide Division, and that she put together this whole thing. She told me what she did, but I asked her at one point when she said we refer the case to the prosecutor's office when an officer-involved shooting is what we're considering. And I asked her, well, do you give some input in that? And she said, yes, sir. And I said, did you do that in this case? And Shannon responded, not too much. And I said, well, I followed that up. What does not too much mean? And she started to answer that. Mr. Teeger interposed an objection, and Judge Giz told Shannon Hine she could go ahead and answer that question. And Shannon Hine, in my opinion, very honestly and very bravely, because she was going contrary to the state which called her as a witness, she responded to me. Based on my time and training with internal investigations, I thought I was looking at an officer-involved shooting where his actions may be determined to be justified based on the events surrounding the actual shooting and taking into consideration the information about the prior conduct of Mr. Dubose and Officer Tenzing. In other words, Shannon Hine looked at the totality of the circumstances. And she came as close as she could to telling you what her opinion was on whether or not Ray Tenzing had committed a crime. And it wasn't that he had committed a crime. Ladies and gentlemen, I would suggest to you that Shannon Hine, who is as close to the investigation of this matter and knows as much about this case as anybody, hit the nail on the head. Ray Tenzing is not guilty of murder. He's not guilty of voluntary manslaughter. And the only appropriate verdicts for you to return to this courtroom with are ones of not guilty. Thank you. Thank you, Judge.
Mr. Teeger, rebuttal.
Did you want me to get started? Or
Yep, I'll take care of that. You just stand up and
Sure, Judge.
have at it. And I'm ready to break, I will.
Sounds good. I'm not sure if I just heard Mr. Matthews right that he equated Ray Tenzing to Sully, but that is around the most ridiculous analogy I've ever heard in my life. But if that's what he's trying to say, so be it. It's hard to go last. I'm sure you all are ready to deliberate and do the job that you were chosen to do. But as an attorney, as you know from all of us, I do have some comments, and I did want to tell you a few of my observations during this trial. There was a Reds game around a month and a half ago, where it was the bottom of the 9th inning, and the Reds were losing 2-1. And there was a man on first, and Billy Hamilton was batting. And Billy Hamilton is around the fastest player in the major leagues. And he had a ground ball in the infield, and there was a play at first base. And the umpire called him out. And the game was over. Reds lose 2-1 because there were 2 outs, and that would have been the 3rd out. But what happened in this case was that the last couple of years, Major League Baseball has adopted instant replay or video replay. And the Reds challenged the umpire's ruling. The umpires looked at that video and they determined that Billy Hamilton was safe. So instead of the Reds losing 2-1, it was 2 outs, men on first and second, and Zach Cozart was up. And he proceeded to get a hit, and the runner on second and Hamilton both scored. And the Reds won 3-2. And the reason I bring that up is that if there were no video, the Reds would have lost. And if there were no video, this man right here would never have been charged. You'd have Alicia Napier, who's saying what she saw, but when you put Alicia Napier against the defendant's version, Lyndon Schmidt and Kidd, it never would have been enough to bring criminal charges. So the miracle of video, the ultimate witness, that video has no bias, that video is completely independent, and that video let this case go forward. This isn't 20/20 hindsight, it's a review of what actually happened. And the most important trait in human affairs is self-preservation. And Ray Tensing lied to Cincinnati police that day on the 21st, and he lied to you when he testified in order to save himself. But in a very ironic twist, his own body-worn camera exposed him as a liar. And there was a question in your questionnaire about police wearing body-worn cameras and what your feelings on that were. And I think all of you said body-worn cameras were a good thing. I think every juror, all of you, everybody else that was in that panel agreed with that. They protect the public from improper police activity, but they also protect the police from false allegations from the people they come into contact with. In this case, it's a clear example of why the body-worn camera is so important. And Mr. Matthews tried to tell you that if Ray Tensing was guilty, he would have just never turned on that body-worn camera. Well, he knows better than that, because we don't have to prove premeditation. Nowhere in that jury instruction will you see from Judge Gibbs that there has to be any, we call it premeditation. That's prior calculation and design. This is just what's called straight murder, not aggravated murder. And are we trying to say that Ray Tensing knew when he walked up to that car what he was going to do? Absolutely not. He did not know that at all. We just have to prove what was in his head at the time the trigger was pulled. It could be that quick, that instantaneous, that impulsive of an act. What was his purpose when he pulled that trigger? Was it to cause Sam Dubose's death? Zero premeditation is required. You're not going to hear that, because a lot of people that you talk to might say, well, how are you going to prove he's guilty of murder? He didn't mean to do that when this happened. Nobody's ever said that, and that is not a part of this case in any way, shape, or form. There's 2 counts or charges, as Mr. Graffenried outlined. And what I'm going to ask you to do is think of each count or charge as a door. So there's 2 doors during your deliberations. The first is the murder door, and the second is the manslaughter door. And the law is that you have to consider murder first. That's what Judge Gibbs will tell you. And if you can't agree on murder, then and only then do you go to manslaughter. And if you look at the evidence as a key, and all of you are at door number 1. All of you are there, you're back in the deliberation room, you're at that murder door, you've got the evidence, which is the key to unlock that door. And if the key doesn't fit, or all of you can't get in that door, then and only then do you move to that second door, which is the manslaughter door. If all of you fit into door number 1, the murder door, you stop your deliberations. The case is over, and he's guilty of murder. If all of you can't agree on murder, then you move to door number 2, which is the manslaughter door. The reason I bring this up is that the guilt as to count 2, the manslaughter, is overwhelming. But the law says you have to start at count 1. You can't start at count 2. The only reason we have count 2 is to prevent a miscarriage of justice if you don't agree with count 1. Count 2 is a lesser charge, less serious, and much less of a major charge than murder. Count 2 is there to prevent a miscarriage of justice if you don't agree with count 1. Why is manslaughter so overwhelming? As Mr. Graffin Reed said, you don't have to show a purpose to kill, just knowingly, which is a much lesser culpable mental state, we call that, than purpose. And there's added factors in that count that mitigate the culpability. And not to use like legal language, but it means to lessen or explain his level of responsibility. In looking at these factors, as Mr. Graffin Reed pointed out on her board and Mr. Matthews commented on, by Sam Dubose attempting to drive away during the middle of a traffic stop that he thought he was controlling, because as you can tell, he's a very controlling person, isn't he? Was serious provocation occasioned by Sam Dubose that explains why he went to that gun so fast. There was no time to reflect for Ray Tensing because he acted so quickly, using deadly force, so rapidly and inappropriately. The serious provocation. The defendant, Ray Tensing, thought he was being fair. How dare him pull the door shut and start to drive away? He needs to let me handcuff him like I did to the driver before when everything went so well. But no, Sam Dubose didn't do that, did he? The defendant just lost control and acted instinctively, which you've heard Mr. Matthews use that word a lot during this trial. He acted instinctively, without time to reflect, based on Sam Dubose's non-compliance. All of that is classic manslaughter. It's a slam dunk guilty of count 2. But again, the state does not believe, based on the evidence, that you will ever get to count 2 because we're asking you to find him guilty of count 1, the murder. Now, even though Sam Dubose did not drag Ray Tensing, Sam Dubose was dragged through the mud in this trial, wasn't he? Very clearly, it's typical in every murder that we do or every rape, where somehow the victim is blamed. The woman did this wrong. The woman was dressed this way. The woman led the person on. Every rape case, you get that. In a murder, the defendant had weed. The defendant did this. Criticized Deshaunda Reed. Well, why was she treated so harshly? But the witnesses, why were they repeatedly asked about these prescriptions or medicine and drugs? Because that was not a factor, because none of it was known to Ray Tensing when he made that traffic stop. It was just an attempt at character assassination of Sam Dubose. And if there was a different type of driver, would the defendant have treated them differently? Now look at who he stopped that day. It was all African Americans for minor traffic violations. You ask yourself, how does that protect UC students? And when Mr. Matthews gets up here and says he made those cuffs more comfortable, when he held him in that car for 30 minutes, handcuffed, maybe he made them less uncomfortable, but you definitely don't make handcuffs more comfortable. You never do. If it were any of us in this room, or your family or your friends, would he have handcuffed us that day? Would he have rejected our attempts 2 different times to give him our name? If you put your friend, yourself, or your family member in the place of Sam Dubose, would you accept the killing as fair and appropriate? I would submit that you would not. Now let's talk about Police Officer Hine. She had 4 months in homicide. She was in and out. She was given this major case as a lead investigator with little or no experience. And I just want to talk about that interview. And you heard it, you had transcripts that you were following along with, and if you want to replay it, you can, but I just want to read some things that were in that interview that I hope you noticed but picked out. Started out, Shannon Hine. And Ray Tensing said, "Ray Tensing, nice to meet you." And Shannon Hine said, "Nice to meet you." And Terry McGuffey said, "Terry McGuffey, nice to meet you, Ray." Officer Hine, "Well, you know why you're here?" He said, "Yes." Police Officer Hine's next comment, "I'm glad that we're here to talk. Sorry about the circumstances, but it's just a formality." And then Ray Tensing said, "Okay." What did that mean to you, ladies and gentlemen? Is that how these officers would treat a so-called regular murder suspect? When Shannon Hine said, "I'm glad we're here to talk," would she have said that to somebody else? When Shannon Hine said, "Sorry about the circumstances around it," what she really meant was, "Sorry, you just killed somebody." And when she said, "It's just a formality," what she meant was, "Don't worry, you're going to get what you want." When somebody says to you, "This is just a formality," it means that, look, you've got to do this, but don't worry about it. That's what Police Officer Hine said to Ray Tensing in the first couple minutes that she met him. And then, moving on towards the end of the interview, is when Police Officer Hine said, "Okay, will you do me a favor and make your fours, make your sevens look like sevens and not fours for me?" And Ray Tensing said, "Okay, Officer Hine, only because here you made it look like a 7. Tensing, I'm sorry, I don't know why I'm writing 4. Hine, that's okay. Tensing, is that okay to just do that? Officer Hine, yeah, that's fine. Does Cole Rain teach you guys how to write? Tensing, pretty much. Hine, French style 7s? Tensing, yeah, probably writing with the wrong hand too. McGuffey, what are they trying to teach you there? Don't feel bad, I was from Mount Healthy. Answer, okay. McGuffey, not all of us can go to Elder. That's what the discourse was between Officer Hine, Officer McGuffey, and Ray Tensing. Do you think that's funny to joke around about where you went to high school during a murder investigation or a shooting investigation? Or was that all too familiar? Was it just a formality? Was this the good old boy network kicking in? Is this how they would have treated anybody else other than an officer? Police Officer Hine said in her testimony there was nothing inconsistent between what Mr. Tensing said and her investigation. What about Alicia Napier, who they had talked to a couple days before? And she said the Dubose car didn't move until after the shot. That's totally inconsistent with what he said. And at the last trial that Officer Hine sat through, she said nothing was inconsistent in that trial, but she heard Grant Fredericks, who said approximately, it went up differently last time than this time, but there were some of the same points. Would they have thrown easy question after easy question to Ray Tensing? To another suspect? No. Why not challenge him with the Napier statement? Why not say, wait a minute, Napier said this, you're saying this, which one's true? Why not say, wait a minute, you reached in, you violated your training, what's the deal with that? They didn't ask him any difficult questions because it was just a formality. If you are Sam Dubose's mom, who's sitting back there, or you are Sam Dubose's sister, who's sitting back there, should you be happy or satisfied that a proper interview and investigation was done by Police Officer Hine and McGuffey? Should they be happy for that investigation? In the UC Police Memo of Understanding that Mr. Matthews mentioned, it's UC helping CPD. There's a close relationship between those departments. And what you have are police judging one of their own. It's police judging police. And the police are amazing people. They're incredibly brave, and a lot of them are just incredible people in the work they do for our county. And a lot of the people that I really look up to are police in Cincinnati and Hamilton County. They are way up there to me. And almost every police shooting that we look at is justified. In my office is criticized by a lot of people because they think we call too many justified. However, there must be a safeguard on police because if they review themselves, they can become too powerful. And it's this review of the police and the military, these checks and balances in our country through the judicial branch, which lets you, the citizens, decide whether something's appropriate, is why we do this. Really, this case is about the justification defense, because as much as Mr. Matthews talks about he didn't do this purposely, he was stopping the threat, that's just legal gymnastics and semantics. You point a gun that close to somebody's head and pull the trigger, your purpose is to end their life, regardless of how that's sanitized or what they're trained to do if they try to psychologically in the police academies get them to distance themselves from what they're actually doing, but everybody knows what they're actually doing when they're stopping a threat is ending somebody's life. You know, Mr. Matthews had some conjecture about why Mr. Tensing said stop, stop. I would submit to you it's just as likely he said that, stop, stop, don't drive away. Don't put that car in drive. And that car is so old, if any of you have driven an old car, like I have a number of times, sometimes that wheel, you've got that wheel turned straight, and that car goes to the left or right, even if you think that wheel is straight. And I'm sure some of you experience that when you've driven older cars. And as far as the justification, that's got to be proven to you by a preponderance of the evidence. And that's a legal definition. It's not just like, oh, well, you know, this or that. It's a legal, strict legal definition. It's got to be proved by him to you. And every defendant that comes into a courtroom with a defense of self-defense or justification, everybody, every single one says, I did it because I had to do it. We have a lot of so-called self-defense trials in this building. It's nothing new. It happens all the time. Now, and I would go through the factors like Mr. Matthews does and Mr. Graffin Reed, but I have a different viewpoint, and I think the evidence supports it. The severity of the crime that the defendant police officer was addressing. There was no driver's license, at the very worst, which they keep calling a serious, serious misdemeanor. I don't know how many times we heard that. But look at the guy before him that they showed. He not only had that charge, but he had 5 warrants. And he just got recited and he was allowed to leave. The severity of the crime he was addressing. He was addressing a very minor traffic charge. Did Sam Dubose pose an immediate threat to the safety of the police officer or others? Absolutely not at the time of that stop. Mr. Matthews saying he was trying to drive to that secluded area to try to get away and lose him? Well, if he wanted to do that, why didn't he just do that instead of stopping? That didn't make sense. Was Sam Dubose actively resisting arrest or attempting to evade arrest by flight? No, because he wasn't under arrest, and he wasn't told he was under arrest. He wasn't evading any kind of arrest by flight. He may have been about to be put in detention, which is not an arrest. And did the defendant police officer play a role in creating the dangerous situation? Absolutely. These are factors the judge will tell you to look at. He doesn't make any one of these. Not one. Much less prove it by a preponderance of the evidence. He failed miserably in his attempt to prove justification. Police do have to make difficult decisions. But it's clear that when he testified here, Mr. Tensing, in the second trial, he clearly knew the law and kept telling you that they weren't there, they don't know what I was feeling, these people can't look at me. Do not buy that argument. Because what makes the difference is the video. And we can judge whether or not it was okay to do what he did. And as far as 2020 hindsight, again, just a notation that I made. Mr. Matthews asked both of our experts, Mr. Fredericks and Mr. Ho, are you using 2020 hindsight? But he didn't ask his own expert whether he was using 2020 hindsight. He didn't ask Mr. Scanlon that question. Again, why didn't he? He's got a job to do, and it's to influence you in making a decision in his favor. It's not contested and it's conceded that when Ray Tensing went to the gun, in that instant, his intent was to shoot Sam Dubose. He told you that on the witness stand, and it's in his statement. When I went to my gun, my intent was to shoot him. And that decision was made well before the car ever moved an inch. His hand went in, the other hand goes back. That decision was made way before that car moved. If you time it out, because it takes time to go from the top of the car, to go to the holster, to do all the safety stuff, and get it to that position that we saw it in. So even if it only took a second to get it out, which would be fast, the evidence shows there was no danger to Ray Tensing when he made the decision to go for his gun, because he said, when I went for my gun, I was going to use it and stop the threat. Way before that car moved. Ray Tensing had a choice to make that evening after the serious tactical error. Do I disengage and let Sam Dubose drive away, or do I kill him? He made the fatal option for Sam Dubose when he acted instinctively like he said he did that day and disregarded all his training. Ray Tensing is not saying that he made a mistake and misperceived the situation that was happening quickly. He's in no way acknowledging that he was wrong and just reacted rapidly to a rapidly evolving situation and fired the gun when he was not in danger. He's not saying that I made a mistake. He is saying and wants you to believe the opposite. Find me not guilty because I actually was actively being dragged and I had no choice. But only he and Mr. Scanlon say that. And even Mr. Matthews said being dragged is the wrong word. And even Mr. Matthews said that Ray Tenzing made a mistake. Ray Tenzing didn't say that. To find him not guilty, you must find that he was being dragged and the use of his weapon was his only option. Again, Alicia Napier, she did see what she thought was Dubose or hear shoot Tenzing, and she thought she heard a second gunshot. But the beauty of her statement and the bravery of Ms. Napier is that her main point is that that shot was made before the car had moved. And maybe it had moved a couple feet, but it's something imperceptible that she may not have noticed. But she made her statement, unlike Ray Tenzing, right at the time this happened, a few hours later. She had not seen the video and had not had time to reflect. Looking back, said, you know what? That second shot I thought was probably that car hitting that guardrail. The UC police did not see dragging. Police Officer Kidd even said that he thought Tenzing lunged in the car with both arms. Now the defendant tried to demonstrate to you a very casual reach. But Police Officer Kidd saw him lunge into the car with both arms. That's what Kidd's perception was. That's how fast and powerful that movement was into the Dubose car. And even though Ray Tenzing said he made no mistake, the thought is that, you know what, I made a mistake, I killed somebody, oops, my bad. It was Sam Dubose's fault anyway. Sorry, my bad. Let's do a do-over. And as far as an observation, I think one of the officers said Ray Tenzing's shirt was untucked. And you saw from, I think, the picture that Mr. Matthews put up, Ray Tenzing's shirt was not untucked at all. The science is very important in this case. You've got Mike Trimpe, no pain transfer. These tests were done, maybe it would have helped Ray Tenzing. Maybe it would have proven a violent contact with that car. And maybe it would have showed that his boots were dragged. And science doesn't lie. It's a testing either helps or hurts, one side or another. That's not part of science. And it was done to try to get to the truth and the bottom line in this case. And he said there is no proof of any of that. No paint transfer, no drag marks over that rough street. If he was being dragged, would you expect some drag marks, especially on his left boot, if he was being dragged up the street like that? And what Karen Lohman told you is the cause of death caused an immediate lack of movement. So anything that happened after that, why the defense showed you all those slides and kept focusing on Ray Tenzing in the street after the homicide, when this other car came by, is irrelevant, because what you have to look at is what happened at the time of the shot, not what happened later. Because Sam Dubose wasn't in control of that car after he was shot and isn't responsible for anything that happened after that. The defense wants you to believe that non-compliance equals not guilty. But that's simply not the case. And all of you in jury selection, we talked about non-compliance. And all of you knew on jury selection that Sam Dubose did not comply. This isn't a surprise or a secret that he didn't comply. We talked about it, we asked questions about it, and this was a topic of discussion during jury selection. Non-compliance does not equal not guilty. The defense attorney is saying that if Sam Dubose would have complied, he wouldn't be dead. And that's probably true. But that's not the issue. Because the issue is he didn't comply. and he shouldn't be dead if he would have handled things correctly. Not reached into that car, let him drive away, and done what any other reasonable police officer would have done. And when they bring up Kevin Crayon, and you look at those factors, it was a 12-year-old boy that was 4 years away from ever being able to drive, that was driving a car that an officer reached in. A 100%, 180-degree different situation than we had here in this case. You cannot compare Kevin Crayon to Ray Tenzing. Did he make a serious tactical error? Did he disregard all his training? Despite what he and his experts say, Mr. Scanlon, he had a choice. Should I disengage? As Mr. Gregory pointed out, his legs were apart from that car. He started that car. Do I stand there and let him drive away? Or do I jump in with my hand and kill the person? He chose option 2. He's saying that Grant Fredericks and Scott Hogue are wrong and that he and Scanlon are right. He's being dragged and he has to do it. That is just not supported by any of the evidence in this case. Look at Sam Dubose's hands when that shot's fired. He knows what's coming. What's going through his head when he sees that gun, and I'm not going to pull out the gun, but I'm not going to try to invade your space, but 1 to 2 feet from his head is the barrel of that gun. When he puts up his hands, you can't stop a bullet with your hands. That had to be the moment that was most terrifying for Sam Dubose, when he couldn't stop what Ray Tenzing was about to do. When you get a police job, when you're hired, you don't follow somebody around for a couple days and just start to do the job. Like some other jobs, you go in, you get hired, you maybe watch the person for a couple days, then you do it. When you're a policeman, you go 6 to 7 months through certified training. There's like that field training officer, so for 3 months, you heard Officer Lynchman said, he had to follow another officer around for 1 month with 3 different training officers. So that's 3 months of being with somebody. Then you've got additional training as you go. Like we heard Chief Hughes talk about, this was additional training that Ray Tenzing underwent. And remember, he was a Green Hills officer prior to that. So Ray Tenzing is not a rookie officer. He's had a lot of training and a lot of experience. Police officers are trained to make split-second decisions all the time. That's what they are trained to do. He is not saying that he misperceived the situation. He's arrogantly sticking to his own version. And the only one that's agreed is his extremely biased expert, Mr. Scanlon. From Sergeant Asbury to Police Officer Kidd, to his own trainer from Caliber Press, Chief Hughes, which is a nationally recognized company, all of them say they stand for the proposition of never to reach into a car. That's what he was taught, regardless of what he says. And if you look at it from the perspective, as Mr. Matthews said, a reasonable officer, and be objectively reasonable, clearly Ray Tenzing fails. And if you look at Ray Tenzing's actions and reactions after the shot was fired, there's no remorse. There is no, oh my God, what did I do? It's all very cold and antiseptic. There's no regard or concern for Sam Dubose in any way. He was not treated as a person, he was treated as a crime scene. And as he lay dead with a bullet through his brainstem, he is gulping down water in a police car complaining that his arm is a little bit tingly. That's what he's doing. At the same time, Sam Dubose is taken out of that car and laid down in the street with a sheet over him. There's no real pain or discomfort to Ray Tensing as he's being slowly driven to the hospital while Sam Dubose is put in a body bag. Because Sam Dubose was trapped in that car during that stop, and he was an easy target when his car became his coffin. No part of the defendant was ever caught on Sam Dubose's car. He keeps talking about his armpit, I think he brought up, that somehow was held up on the car, his armpit area, and his shoulder was somehow against the rearview mirror. But there's absolutely no injury to these areas in any way. There's no injury seen, there's no injury complained of, there's nothing wrong with his armpit or his shoulder that are supposedly the focal points of him being trapped in that car. And he got a thorough exam by a doctor, and these were not things that he complained of or was in pain in any way. He lied to the police and he lied to you during his testimony. And it's insulting to the evidence in the video that he can take an oath in a courtroom in front of all these people and try to fool you with his fake sincerity. Because the evidence clearly does not support his contention in this case. No one is disagreeing that Sam Dubose should have complied. Again, there was no surprise in this evidence. The issue is, and we knew a long time ago, recognizing and accepting the non-compliance. A reasonable, objective police officer, how would they have handled that? And they would not have done what Ray Tensing did. As far as the quality of the experts are there to assist you in your understanding of the case because of their education, training, and background. It's kind of funny that Mr. Matthews never asked Mr. Roeder to be an expert witness, but the other witnesses, Fredericks, Hogue, and Scanlon, we all agreed that they were expert witnesses. Both Scott Roeder, he never tendered, and we never agreed that he was an expert. But when he said, and hopefully you remember, when he said that Mr. Matthews, I think on redirect, showed a picture of that car in the middle of the street, the car going the other way, and said, well, let me look at that car, do you see the brake lights? And Mr. Roeder said, yeah, I see those brake lights. And Mr. Matthews said, what's that mean to you? And Mr. Roeder said, obviously that car was stopped. Well, that car wasn't stopped. How many of you have driven down a hill, and when you drive down a hill, you tap on or your brakes are slightly on because you don't want to fly down that hill? He lost all credibility when he said obviously that car was stopped because the brake lights were on. And if he brought up and name dropped Johnny Cochran one more time, and I'm sure Johnny Cochran was a great attorney, but he's been deceased since 2005. So you've got Grant Fredericks and Scott Hogue against Scanlon. Only one forensic video analyst, Grant Fredericks. His testimony was uncontroverted. Because Hogue and Scanlon are just use of force experts. They're not forensic video analysts. And Scanlon is extremely biased for the police. He shot 3 people. And before this incident, he testified 3 times for the police. 2 times he has now testified for Tensing, so a total of 5 times. And he said 2 times he offered to testify for other officers, but they declined. Do you wonder why they declined? Seeing his performance in here on Friday, why those officers didn't want anything to do with him? Grant Fredericks said he's 50-50 between supporting police and rejecting their opinion. It's around half and half. Scott Hogue told you prior to this case, he's testified 12 times. 11 times for an officer, and only one time against. This was only the second time he's ever testified against an officer. He said there was a serious tactical error and that once his arm was in the car, even though he made that error, he could have and should have disengaged. That's what Chief Hogue said. 11 times for an officer, 1 time against. Who is impartial in this case? Whose expert opinion should you rely on? And Chief Hughes personally taught the class where it was stressed never to reach into a car. Sergeant Asbury, who was a defense witness. Most times he's a state's witness, and I think the evidence shows he was extremely credible. And he talked about his training, and he said he was told never to reach into a car. And I asked him, well, have you ever done it? And he described to you that if somebody's OD'd, maybe deceased or unconscious from like a drunk driver, that he will and has reached into a car from the passenger side. And he explained to you why he did that. And he also told you the one time when he was a rookie officer in 2005, there was somebody shot, and they followed the car that dropped the person off at the hospital. And he had a chance to reach into that car when that person started the car and attempted to leave. And what did Asbury do? What Tensing should have done. Stay where you are, let the car go, and pursue. They had the license plate, they had the name, they had Deshaunda Reed, they had Sam Dubose's image captured on body cam. He would have been easy to find. But he acted instinctively. No police officer testified that they have ever done or tried to do what Ray Tensing did that night. You all saw his attitude and demeanor during this trial. He acted sad. He acted like he was crying. And do you recall when he recited his accomplishments to you on Friday about his background? It seemed almost word for word what he said in his statement. But on his statement on July 21st, there was no tears, there was no remorse, there was no crying, there was no emotion. It was very matter of fact. Why? Because it was just a formality, wasn't it? Because he's going to get what he wants. But now that he's facing criminal charges, those tears are not for Sam Dubose, they're for himself. Because he feels sorry for himself. And I'm sure he's thought about it every day for the last couple of years. And why is that? Because he's been indicted and facing criminal charges and he's thinking how to get out of it. That's why he's thinking about it so much. And ask yourself, if there was no video, and there were no charges, and there was no crime, and he just went back on duty as a police officer, how would he be acting then? Would Sam Dubose be an afterthought and a distant memory? Absolutely. Ray Tensing is saying that his conduct should be legally excused, permitted, and justified. If you or your family work for like a bigger company or employer, there's something called the FMLA, the Family Medical Leave Act, that the company must keep open your job for a period of time. And your absence is legally permitted and justified in that case, for an illness, a pregnancy, or for other medical reasons. Jury duty, you may not get paid, but your employer cannot fire you for being on jury duty. If a student has their wisdom teeth out and misses a couple days of school, you get a note from the doctor that that excuse is legally justified and permitted. When you deliberate, ask yourself, does our law in Hamilton County legally allow Ray Tenzing to kill Sam Dubose that evening. By signing a not guilty verdict, you're saying, in signing that doctor's note for Ray Tenzing, that excuse for him, because a not guilty verdict is signing that note. Sign the verdict not for justification, but one of justice for Sam Dubose that is guilty of murder. Thank you.
Okay, ladies and gentlemen of the jury, I'm going to need about 20 more minutes of your time to read you the jury instructions. Before I get started, I want to let you know, please pay attention to what I'm saying, but I will send this copy back with you. So you will have it in the back. If there are any questions, you go right to it. I'm just reading it verbatim. So don't anyone panic if you miss a part of it, because you can always go back and look once you get in the back. Ladies and gentlemen of the jury, you have heard the evidence and the arguments of counsel. It is my duty to instruct you on the law that applies to this case. The court and the jury have separate functions. You decide the disputed facts, and the court provides the instructions of law. If it is your sworn duty to accept these instructions and to apply the law as it is given to you, you are not permitted to change the law nor to apply your own conception of what you think the law should be. A criminal case begins with the filing of an indictment. The indictment merely informs the defendant that he has been charged with a crime. The fact that it was filed may not be considered for any other purpose. The plea of not guilty is a denial of the charge and puts in issue all the essential elements of the crime. The burden of proof. The defendant is presumed innocent until his guilt is established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence that convinces you beyond a reasonable doubt of every essential element of the offense charged in the indictment. Reasonable doubt. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say you were firmly convinced of the truth of the charge. Reasonable doubt is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. Evidence and inferences. What is evidence? Evidence is all the testimony received from the witnesses, the exhibits admitted during the trial, and any stipulations entered into by counsel. State's Exhibit 9A is the video recording of the defendant's interview with the Cincinnati police on July 21st, 2015. Several breaks were taken during the interview, and during some of those breaks, the defendant was present in the interview room with his attorney. By the agreement of the parties, those sections of the interview have been redacted from the interview. There is also a few-minute segment of the interview where the officers are questioning the defendant about damage to his uniform, where the video did not record what was taking place, but the audio was functioning properly. Both sides agree that the complete audio part of the interview was recorded on the disc, and the only thing missing is a few minutes of video. Evidence may be direct or circumstantial, or both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which he or she testifies. It includes exhibits admitted into evidence during the trial. Evidence may also be used to prove a fact by inference. This is referred to as circumstantial evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other reasonable facts or conclusions. Circumstantial evidence and direct evidence inherently possess the same probative value and therefore are subjected to the same standard of proof. Where the evidence is both direct and circumstantial, the combination of the two must satisfy you of the defendant's guilt beyond a reasonable doubt. You may not make one inference from another inference, but you may draw more than one inference from the same set of facts. The evidence does not include the indictment, the opening statements, or the closing arguments of counsel. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. Statements and answers that were stricken by the court or which you were instructed to disregard are not evidence and must be treated as though you never heard them.
You must not speculate as to why the court sustained the objection to any question or what the answer to such question might have been. You must not draw any inference or speculate on the truth of any suggestion included in a question that was not answered. Exhibits. A number of exhibits and the testimony related to them have been introduced. You may consider whether the exhibits are the same objects in the same condition as originally taken. You will determine what weight, if any, the exhibit should receive in light of all the evidence. Recordings and testimony relating to them have been introduced into evidence. You shall consider whether the recordings are a true record of what transpired at the time they were taken. If you find that they are, you will then determine what weight, if any, the recording should receive in light of all the evidence. Stipulation. Stipulations. The lawyers are permitted to stipulate that certain facts exist. This means that both sides agree those facts do exist and are part of the evidence. You are to treat a stipulation as any other evidence. Meaning of words. Remember that words in the English language, whether used in this charge or in the evidence you are to weigh, are to be given their normal and customary meaning in the English language unless you are specifically instructed to give them some specialized or different meaning in this charge. The instruction on interpretation should govern you throughout your deliberations. Expert witnesses. Generally, a witness may not express an opinion. However, one who follows a profession or special line of work may express his opinion because of his education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you arrive at a just verdict. Questions have been asked in which expert witnesses are permitted to assume that certain facts were true and to give an opinion based on such assumption. You must determine whether the assumed facts upon which the experts base their opinion are true. If any of the assumed facts was not established, you will determine its effect upon the opinion of the experts. However, as with all other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of the experts. In determining its weight, you may also take into consideration their skill, experience, knowledge, veracity, familiarity with the facts of this case, and the usual rules for testing credibility and determining the weight to be given to testimony. Credibility. You are the sole judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witnesses. You will apply the tests of truthfulness that you apply in your daily lives. These tests include the appearance of each witness upon the stand, his or her manner of testifying, the reasonableness of the testimony, the opportunity he or she had to see, hear, and know the things concerning which he or she testified, his or her accuracy of memory, frankness or lack of it, intelligence, interest and bias, if any, together with all the facts and circumstances surrounding the testimony. Applying these tests, you will assign the testimony of each witness such weight as you deem proper. You are not required to believe the testimony of any witness simply because he or she was under oath. You may believe or disbelieve all or part of the testimony of any witness. It is your province to determine that what testimony is worthy of belief and what testimony is not worthy of belief. Police officers. We had witnesses who were police officers. They are tested by exactly the same tests of believability as any other witnesses. They are not entitled to any more credibility nor any less credibility simply because they are officers of the law. As with other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of the police officers. The testimony of the defendant. The testimony of the defendant is to be weighed by the same rules that apply to other witnesses. Time and place. The indictment charges that the crimes alleged took place on or about the 19th day of July in the year 2015. It is not necessary that the state prove that the crimes were committed on the exact day that is charged in the indictment. It is sufficient to prove that the offenses took place on a date reasonably near the dates claimed. The indictment also charges that crimes took place in Hamilton County, Ohio. Before you can decide whether the state of Ohio has proved beyond a reasonable doubt all of the essential elements of the offenses with which the defendant is charged, you must first decide whether this is the correct county in which this trial should be held. The state must prove beyond a reasonable doubt that all or any part of the crimes were committed in Hamilton County, Ohio. The right of this court to try the defendant depends upon the proof that the crimes were committed in Hamilton County. Consider the counts separately. The charges set forth in each count in the indictment constitute a separate and distinct matter.
You must consider each count and the evidence applicable to each count separately, and you must state your finding as to each count uninfluenced by your verdict as to any other count. The defendant may be found guilty or not guilty of any one or all of the offenses charged. The court will now outline and define the specific issues involved in this case. Count 1, murder. The indictment charges that the defendant in count 1 with murder, a violation of the Ohio Revised Code section 2903.02a. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 19th day of July in the year 2015 in Hamilton County, Ohio, the defendant purposely caused the death of Samuel Dubose. Purposely. Purpose is an essential element of the offense of murder. A person acts purposely when it is his specific intention to cause a certain result. It must be established in this case that at the time in question, there was present in the mind of the defendant a specific intention to cause the death of another. Purpose is a decision of the mind to do an act with a conscious intent to produce a specific result or engage in specific conduct. To do an act purposely is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act is known only to that person unless he expresses it to others or indicates it by his conduct. The purpose with which a person does an act or brings about a result is determined from the manner in which it is done, the means or weapon used, and all the other facts and circumstances in evidence. You may infer a purpose to cause the death of another when the natural or probable consequence of the defendant's act is to produce death in light of all the surrounding circumstances. Such circumstances include the weapon use and its capability to destroy life. If you find that the defendant used a deadly weapon against another in a manner calculated to destroy life, you may, but are not required to, infer the purpose to cause death from the use of the weapon. Whether an inference is made rests entirely with you. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose. Where an act is a crime, a good motive or purpose is not a defense. Deadly weapon. Deadly weapon means any instrument, device, or thing capable of inflicting death and designed or specifically adapted for the use as a weapon, or possessed, carried, or used as a weapon. A deadly weapon is any instrument, device, or thing that has two characteristics. The first characteristic is that it is capable of inflicting or causing death. The second characteristic is in the alternative. Either the instrument, device, or thing was designed or specifically or specially adapted for the use as a weapon, or it was possessed, carried, or used in this case as a weapon. There are questions of fact for you to determine. These are questions of fact for you to determine. Proof of fear or apprehension on the part of the person against whom the weapon is used or threatened is not required. Causation. Cause is an essential element of the offense of murder. Cause is an act or failure to act which in a natural and continuous sequence directly produces the death and without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act or failure to act. The defendant is also responsible for the natural and foreseeable consequences or results that follow in the ordinary course of events from the act or failure to act. Affirmative defense, justification. The defendant, Ray Tensing, maintains that his use of deadly force against Samuel Dubose was reasonable and lawful in the exercise of his official duties as a police officer and therefore justified because he feared that the actions of Samuel Dubose would cause death or serious physical harm to the defendant. To establish this defense of justification, the defendant must prove that he was justified in using deadly force by a preponderance of the evidence. Preponderance of the evidence. Preponderance of the evidence is the greater weight of the evidence, that is, evidence that you believe because it outweighs or overbalances in your mind the evidence opposed to it. A preponderance means evidence that is more probable, more persuasive, or of greater probative value. It is the quality of the evidence that must be weighed. Quality may or may not be identical with quantity. In determining whether or not an issue has been proved by a preponderance of the evidence, you should consider all of the evidence bearing upon that issue regardless of who produced it. If the weight of the evidence is equally balanced, or if you are unable to determine which side of an issue has the preponderance, then the defendant has not established such defense. If the defendant fails to establish the defense of justification, the state still must prove to you beyond a reasonable doubt all the elements of the crimes charged. Use of deadly force. The standard of law to be applied in determining whether the use of deadly force by a police officer is justified is as follows. Deadly force may be used if the officer reasonably believes that such force is necessary to defend himself from the actual use or imminent use of physical force by the suspect that poses the threat of death or serious physical harm. If such circumstances exist, then the officer's use of deadly force is not unreasonable. The test of reasonableness requires careful attention to the facts and circumstances, including but not limited to the severity of the crime that the defendant police officer was addressing, whether Samuel Dubose posed an immediate threat to the safety of the defendant police officer or others, whether Samuel Dubose was actively resisting arrest or attempting to evade arrest by flight, and whether the defendant police officer played a role in creating the dangerous situation. Reasonableness. The reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene rather than with the 20/20 vision of hindsight. The determination of reasonableness must allow for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. The test of reasonableness is not capable of precise definition or mechanical application. The reasonableness inquiry is an objective one. The question is whether an officer's actions were objectively reasonable in light of all the facts and circumstances confronting him without regard to his underlying intent or motivation. If you find that the state proved beyond a reasonable doubt all of the essential elements of the crime of murder, your verdict as to count 1 must be guilty. However, if you find that the state failed to prove beyond a reasonable doubt all the essential elements of the crime of murder, or if you find that the defendant's use of lethal force was justified, your verdict as to count 1 must be not guilty. Count 2, voluntary manslaughter. The indictment charges the defendant in count 2 with voluntary manslaughter, a violation of the Ohio Revised Code, section 2903.03a. You should only consider count 2 if you are unable to unanimously find the defendant guilty of murder as charged in count 1. If you unanimously find the defendant guilty of murder in count 1, you are not to consider count 2. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 19th day of July in the year 2015 and in Hamilton County, Ohio, the defendant knowingly caused the death of Samuel Dubose. While the said defendant was under the influence of a sudden passion or in a sudden fit of rage, either of which was brought on by serious provocation occasioned by the victim that was reasonably sufficient to incite the defendant into using deadly force. The state of Ohio has the burden of proving the defendant knowingly caused the death of Samuel Dubose in count 2, voluntary manslaughter. Neither the state of Ohio nor the defendant, Raymond Tensing, has the burden of proving that the defendant was under the influence of sudden passion or in a sudden fit of rage, either of which was brought on by a serious provocation occasioned by the victim that was reasonably sufficient to incite the defendant into using deadly force. These are factors that mitigate the culpability of the defendant and not elements of the crime of voluntary manslaughter. If you find evidence of sudden passion or in a sudden fit of rage, either of which was brought on by serious provocation occasioned by the victim that was reasonably sufficient to incite the defendant into using deadly force, such evidence can come from evidence produced by the state of Ohio or by the defendant. Knowingly. A person acts knowingly regardless of purpose when the person is aware that the person's conduct will probably cause a certain result or be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. Because you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that he caused the death of another. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon knowledge. When an act is a crime, a good motive or purpose is not a defense. Causation. Cause has been previously defined. Sudden passion, sudden fit of rage. Under the influence of a sudden passion or in a sudden fit of rage means if there is serious provocation occasioned by the victim that is reasonably sufficient to incite a person into using deadly force. It is an act done in the heat of blood without time to reflect or for passions to cool. Serious provocation. For provocation to be reasonably sufficient to bring on sudden passion or a fit of rage, you must decide that the provocation was sufficient to arouse the passions of an ordinary person beyond the power of his or her control. Emotional state of defendant. When deciding whether the defendant was actually under the influence of a sudden passion or a sudden fit of rage, you must consider the emotional and mental state of the defendant and the conditions and circumstances that surrounded him at the time of the act. Deadly force. Deadly force means any force that carries a substantial risk that it will proximately result in the death of any person. Substantial risk. Substantial risk means a strong possibility as contrasted with a remote or even significant possibility that a certain result may occur or that certain circumstances may exist. Affirmative defense justification. The defendant, Ray Tensing, maintains that his use of deadly force against Samuel Dubose was reasonable and lawful in the exercise of his duties as a police officer and therefore justified because he feared that the actions of Samuel Dubose would cause death or serious physical harm to the defendant. Justified use of deadly force has been previously defined for you. If you find that the state proved beyond a reasonable doubt all of the essential elements of the crime of voluntary manslaughter, your verdict as to count 2 must be guilty. However, if you find that the state failed to prove beyond a reasonable doubt all of the essential elements of the crime of voluntary manslaughter, or if you find that defendant's use of lethal force was justified, your verdict as to count 2 must be not guilty. Conclusion. If you find that the state proved beyond a reasonable doubt all the essential elements of any one or more of the offenses charged in the separate counts of this case, your verdict must be guilty as to such offense or offenses according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of any one or more of the offenses charged, or if you find that defendant's use of lethal force was justified, your verdict must be not guilty as to such offense or offenses according to your findings. You will have with you in the jury room the following forms of verdicts. No inference is to be drawn from the order in which I read these to you. Okay, ladies and gentlemen, you'll have 4 verdict forms. The first one is the case caption, and it says, Count 1, not guilty verdict. We, the jury in the issue, join, find the defendant, Raymond M. Tensing, not guilty of murder, a violation of the Ohio Revised Code 2903.02a as charged in Count 1 of the indictment. You will see that there are 12 spots at the bottom for you to sign your name. The foreperson will sign on the bottom right. It's indicated where the foreperson signs their name. All 12 of you must sign if that is the case. The same case caption, Count 1, guilty verdict. We, the jury in the issue, join, find the defendant Raymond M. Tensing guilty of murder, a violation of the Ohio Revised Code 2903.02a as charged in Count 1 of the indictment. It looks identical, except this one is a guilty form. It has 12 spots for you to sign with the foreperson at the bottom, and the bottom right. Verdict form number 3. It looks exactly the same in the case caption. It says Count 2, not guilty verdict. We, the jury in the issue, join, find the defendant Raymond M. Tensing not guilty of voluntary manslaughter, a violation of the Ohio Revised Code, section 2903.03a as charged in Count 2 of the indictment. It looks identical to the other ones, except this is a not guilty on Count 2. And the final verdict form, the case caption is the same. It says Count 2, guilty verdict. We, the jury in the issue, join, find the defendant Raymond M. Tensing guilty of voluntary manslaughter, a violation of the Ohio Revised Code, section 2903.03a as charged in Count 2 of the indictment. Identical to the others, except this is Count 2, guilty verdict. When you have reached a verdict, you will complete the form that corresponds to your decision. You will notice that there are 4 verdict forms, and there are 12 lines on each one of the verdict forms. Those individuals agreeing upon a certain verdict will sign in ink on the line indicated for their signature. All 12 of you must agree on the verdict. The person who is selected as the foreperson will sign in the lower right-hand corner on the line indicated for his or her signature. You may not discuss or consider the subject of punishment. It is your duty to carefully weigh the evidence, to decide all the disputed facts, to apply the instructions of the court to your findings, and to render your verdict accordingly. Your duty is confined to the determination of guilt or innocence of the defendant. In the event you find the defendant guilty, the duty to determine the punishment is placed by law upon the court. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all the evidence, make your findings with intelligence and impartiality, without bias, sympathy, or prejudice, so that the state of Ohio and the defendant will feel that their case was fairly and impartially tried. If during the course of this trial the court said or did anything that you consider an indication of the court's view on the facts, you are instructed at this time to disregard it. Your initial conduct upon entering the jury room is a matter of importance. It is not wise to immediately express a determination to insist upon a certain verdict because your sense of pride may be aroused. You may hesitate to change your position even if convinced that it is wrong. Consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement, if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should not surrender honest convictions in order to be congenial or to reach a verdict solely because of the opinion of other jurors. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide all disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdict accordingly. If during deliberations a question arises as to the evidence you have heard or the law as I have given it to you, place any request in writing and signal the bailiff and deliver it to the bailiff. Do not ask questions hastily without first searching your collective memory for the answer or without reviewing the instructions I have given you. When you ask a question of the court, the court will call the parties and counsel back to the courtroom and review with counsel how or if the question should be answered. If your question can and should be answered, it will be answered. I want to just make a note here, ladies and gentlemen, that it is the practice of this court, two things. I don't let you have notepads. That's why no one has had a notepad during the trial. The second thing is I do not give you transcripts of testimony. So when you are deliberating, if a question arises, the first thing you do is go to the jury instructions if you have a question. I promise you, 9.9 times out of 10, your question is answered in the jury instructions. So please review those very carefully and see if you can answer your own question. The second thing is, if you have a question asking for a transcript, I will not give you a transcript to review. So that will not be possible. And finally, I do this so that you refer to your collective memory, to what you see, to the evidence that's presented to you in the back, and so that you can collectively make a decision versus going to something and going to a transcript to review what someone may have said that you may not remember from your collective memory. The court will place in your possession the verdict forms and copy of the charge that I am reading to you. You will first select the foreperson. The foreperson will retain possession of these records, including the verdict, and return them to the courtroom. The foreperson will see that your discussions are orderly and that each juror has the opportunity to discuss the case and to cast his or her vote. Otherwise, the authority of the foreperson is the same as any other juror. Until your verdict is announced in open court, you are not to disclose to anyone else the status of your deliberations or the nature of your verdict. Juror numbers 78, 84, 87, and 90 are alternates. You must return to the jury commissioner's office where you will be kept separately. By the way, don't panic. Dave will take care of you and he'll let you know where we need to have you go. But you will have to remain during the course of deliberations in the event we run into a problem with one of the jurors, okay? You must not discuss the case with anyone or disclose to anyone how you would have voted. After the jury has returned its verdict and the verdict is announced in open court, the bailiff will contact you and you will be released from these restrictions. In the event of a misfortune to a current juror, you will be recalled to deliberate, so you must conduct yourselves in accordance with the admonitions I have given throughout this trial. Is there anything else from counsel at this time?
May we approach, Your Honor?
You may, Mr. Matthews. Come over here. Select, the first thing you'll do is select a four-person, and whenever all 12 of you, and I am going to repeat this, and it actually says in here, and I repeat, 12 jurors agree upon a verdict, you will sign the verdict in ink and advise the bailiff by using the telephone in the jury room. You will then be returned to the courtroom. At this time, I'm going to excuse you to go back and to begin your deliberations, and Dave will bring the jury instructions and the evidence back to you shortly, okay? Thank you, ladies and gentlemen.
All rise.